Good afternoon. My name is Octavia Gomez, and I am Avery Becker.
Good afternoon. My name is Maisie Bogich, and I am Taylor Perkins.
Good afternoon. My name is Thomas Daneza, and I am Professor Blake Van Allen.
Are there any other are there any conflicts with any of the scoring panelists? There are none for the judge. All right. Let me swear everyone in. I'll start with the team members. Can the team members please raise your right hand? Okay, right hands, I guess I should have said. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Okay. Now, witnesses, can you please raise your right hands? Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and the procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
So now, scoring panelists, please raise your right hands. Okay. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Yes, Your Honor.
All right. Are there
Yes, Your Honor.
are there any gallery members? I think because we're doing it on Zoom, that's not the case. Okay. So why don't we just get started? And why don't we just start with opening statements?
Your Honor, before we begin, the prosecution does have a brief pretrial matter to cover.
All right.
Thank you. It is the people's understanding that the judge, the jury, and the witnesses have all been provided with copies of the exhibits in advance of this proceeding. For that reason, we would like permission to constructively publish exhibits, meaning that we will just refer the attention of the witness, the jury, and the judge towards those exhibits. May we have permission to do so?
Is there any response from the defense on this?
I have no objection, Your Honor.
All right, I will allow that. That makes sense.
Thank you very much.
All right, we're ready to begin. So we'll start with the opening statement for the prosecution.
Your Honor, if I may, the defense also does have some brief pretrial matters.
Oh, okay, sure.
Your Honor, we do request that the stipulated facts be effectively read into the record and published to the jury.
Okay. Is there any objection to that for the prosecution?
No objection, Your Honor.
All right, have you agreed between counsel what your who's going to read the stipulated facts into the record?
Your Honor, our understanding is that they are effectively read into the record.
Okay, great. Okay, we'll do
Your Honor,
that.
we would also like to confirm the screen sharing process and that exhibits are not seen by the jury when they are shared, and they are only seen by the jury when they are entered into evidence.
Is there a response from the prosecution to that?
Your Honor, given that we will be publishing exhibits constructively, we do agree to that condition for screen sharing.
That makes sense.
And Your Honor, finally, we do ask, given that the opposing team did not only introduce the names of their witnesses, we would like to clarify the genders of the witnesses for use in trial.
All right, do you have any response to that?
Yes, Your Honor.
Prosecution?
Our first witness, Alex Cifuentes, played by Reese McKinney, will use he, him pronouns. Our second witness, who is Kyle Cusack, played by Dylan Schneider, will use he, him pronouns. Our third witness, Jordan Markowitz, played by Katarina Schinkel, will use she, her pronouns.
Thank you, Your Honor. No further from the defense.
All right, can you do you want the same information? Does the prosecution want the same information from the defense? Or need it? All
That would be completely acceptable to us. Thank you.
right, can the defense provide the same information?
Your
As to
Honor,
your
today in
witnesses.
trial, Ms. Avery Becker, the defendant, is a female. Ms. Taylor Perkins is also a female, and Professor Blake Van Owen is a male.
All right, thank you. Any other pretrial matters?
No, Your Honor, the defense is ready to proceed.
How about for the prosecution? Are there any?
As is the
Okay.
prosecution,
All
Your
right.
Honor. I apologize.
We're all used to this process by now. But anyway, so let's start now with the opening statements. So we'll start with the prosecution.
Thank you, Your Honor. Your Honor, members of the jury, the defendant, Avery Becker, wanted to get back at Mackenzie Brackman if it was the last thing that she did. We are gathered here today because Mackenzie Brackman was murdered on March 6 of 2020. On that day, Mr. Brackman's Ring doorbell system recorded a masked intruder entering the back of his home, and the following morning he was found stabbed in the back with a large kitchen knife. Mr. Brackman was a local criminal defense lawyer, but was also the head coach of the Colorado High School mock trial team. Just days before Mr. Brackman's murder, the defendant, who was a senior on the CHS mock trial team, was angry with Mr. Brackman, for she had been kicked off the team after vandalizing Mr. Brackman's car. The defendant was so angry after the incident, angry enough to say, "I would get back at him if it was the last thing that I did. If he's still upset about his car, just wait until he sees what I do to his house. I'm going to wait until he's at work, break in, and trash it." Now, anyone can tell you that Mr. Brackman and the defendant had a rough relationship, but it went beyond the typical feud. Now, the defense wants a riveting explanation for what happened to Mr. Brackman, not the simple answer of what did. See, the facts in this case are straightforward, ladies and gentlemen, despite what the defense may tell you. Today, the prosecution will call 3 witnesses, Alex Cifuentes, Kyle Kuzak, and Detective Jordan Markowitz, who will attest to all of the facts in this case today. You will first hear from Alex Cifuentes, a fellow CHS mock trial student, who will attest to the repetitive history of aggression the defendant exhibited. Mr. Cifuentes will also talk about his firsthand observations of the unusual feud the defendant had with Mr. Brackman, and confirm that the defendant sent him messages saying, "If Mr. Brackman is still upset about his car, just wait until he sees what I do to his house. I'm going to wait until he's at work, break in, and trash it." The defendant sent these messages just days before Mr. Brackman's murder. You will next hear from Kyle Kuzak, a Colorado Bureau of Investigation certified crime scene reconstruction investigator, who will confirm that Mr. Brackman's death was a result of a burglary gone wrong when Mr. Brackman confronted an intruder breaking into his home. Mr. Kuzak will explain how he reached this conclusion using detailed reconstruction analysis. You will last hear from Detective Jordan Markowitz, the homicide detective who investigated Mr. Brackman's death. Detective Markowitz will explain how she followed the evidence to the best conclusion and that Mr. Brackman's death was a result of a burglary gone wrong. Detective Markowitz will also explain how our investigation went in the unlikely direction towards the CHS mock trial team and the defendant, where upon further investigation, she obtained text messages between the defendant and Alex Cifuentes, where the defendant clearly planned to wait until Mr. Brackman was at work, break into his home, and trash it. Detective Markowitz also obtained cell tower data from the defendant's phone. This data reveals that the defendant's phone traveled from their home, taking the most logical route to Mr. Brackman's home, placing the defendant's phone in the vicinity of Mr. Brackman's home at the time of his murder. Now, today, the prosecution must prove beyond a reasonable doubt that the defendant, while committing second-degree burglary, committed a felony murder in the first degree. Under Colorado law, second-degree burglary is when a person either knowingly breaks into or unlawfully enters a dwelling with the intent to commit criminal mischief against another person or property. Felony murder is when, while in the course of committing second-degree burglary, an individual attempts to commit or commits the death of another person. In this case, the evidence will prove beyond a reasonable doubt that the defendant, while committing second-degree burglary, committed a felony murder in the first degree. Though the defense may offer an alternative theory, we ask you to remember to follow the evidence. The defense's case is backed by the assumption that the defendant's alibi is sound, despite the fact that the only person who can confirm it is the defendant's best friend, Taylor Perkins, someone who is willing to do anything for their best friend. The defendant claims that their threats were made in the heat of the moment and they would never act upon them, but the evidence and testimony that will be heard today will prove that they did. See, the defendant was someone who had a history of aggression and an unusual feud with Mr. Brackman. They were angry for being kicked off the mock trial team, and the facts will show that she acted upon that anger once again. For she would get back at Mr. Brackman if it was the last thing that she did. Members of the jury, we implore you to follow the evidence to the best straightforward conclusion. We urge you to return a verdict of guilty. Thank you.
All right, thank you, Ms. Martin. And now for the defense. Opening statement.
Yes, Your Honor. May it please the court. I'm Ella Damon, along with my co-counsel. We represent Ms. Avery Becker. The prosecution just told you this case is about the defendant's revenge against her mock trial coach. It's not. It's about a careless and clumsy investigation by the Denver Police Department, making a mockery of justice. The victim, Mackenzie Brackman, coached a Colorado high school mock trial team. Mock trial is a pretend competition where students act as lawyers and witnesses, similar to what you will see today. But there are no consequences if you lose mock trial. No one's life is on the line in mock trial like Avery Becker's is today. Avery Becker last year was a senior and it was her 4th year on the team. She is talented and smart and had bright plans for her future. She would not jeopardize this future for an extracurricular activity. Avery Becker and Coach Brackman had a complicated relationship. They both needed each other to succeed in mock trial, but they didn't particularly like each other. You will hear about the constant criticism Coach Brackman dished to Miss Becker in practice, but mock trial was easy for her. She was a natural, and Coach Brackman resented that. The evidence will show at last year's regional mock trial tournament, Miss Becker won 2 awards. Coach Brackman became even more irritated and said some deplorable things to her. And Miss Becker, who was still just a high school student, was upset. She took a marker and wrote on his car. A childish mistake, and she felt horrible about it. She tried to apologize, but Coach Brackman wouldn't have it and threw her off the team. Now, although Miss Becker will tell you she was upset, she was not angry enough to murder her coach. She would throw away her entire future over participating in mock trials. The evidence will show the night before Coach Brackman died, March 5th, 2020, Miss Becker and her best friend Taylor Perkins went to the fry shack. The next morning, Miss Becker will tell you how she realized she had lost her phone, so she, Miss Perkins, skipped school that day and drove around looking for it. Miss Perkins will tell you she was with the defendant the entire day. Now, prosecution claims to trace Miss Becker's location using her cell phone geolocation data by pinging off various cell phone towers, but you will see a gaping hole in that evidence. First, cell phone data only shows where a cell phone is within a wide range, not the exact location of the cell phone. Second, the data only shows where a cell phone is within a wide radius, not who has possession of the cell phone. Miss Becker did not have her phone on her person March 6, 2020. Someone else must have. In addition to hearing from Ms. Perkins and Ms. Becker, you will hear from Professor Blake Van Owen, whose expertise is crime scene reconstruction, cell phone tower analysis, and police investigation. Professor Blake Van Owen will explain prosecution's theory, Coach Brackman's murder, is inconsistent with the evidence. He will explain how investigator Kyle Kuzak's photographs were conveniently corrupted. The victim is photographed without shoes, but somehow made scuff marks in an altercation with the perpetrator. The prosecution claims the murder weapon came from a block of knives, but the knife that killed Coach Brackman's handle doesn't match the one in the knife block. Now, Detective Jordan Markowitz will testify about how the investigation process was conducted, but listen carefully, because more important than what was done is what wasn't done. The prosecution just told you you will see text messages between Miss Becker and another mocker, Alex Cifuentes, but Detective Markowitz only received and relied on screenshots of these alleged texts and didn't look at the actual cell phone. Nor did Detective Markowitz receive or request cell phone data from Miss Perkins' phone to confirm Miss Becker's alibi. Miss Becker and Miss Perkins' phone data was simply ignored, unless it appeared to the benefit of the prosecution. But the biggest mockery of justice, Professor Blake Van Owen will explain, is that Detective Markowitz zeroed in on one suspect, Avery Becker, from the get-go. She didn't entertain any other possible suspects, such as Blair Rollins, whose father's in jail because Coach Brackman lost his criminal trial. Avery Becker is charged with 2 crimes, first-degree murder and second-degree burglary. Because the prosecution has burden of proof, it must prove every element of these charges beyond a reasonable doubt. At the close of evidence, you will see the only way to stop this mockery of justice is if you find Ms. Becker not guilty.
Thank you, Counselor. Can we have the prosecution's first witness, please?
Yes, Your Honor. The prosecution would like to call Alex Cifuentes to the stand. Your Honor, may I proceed?
Yes, you may.
Thank you. Good afternoon. Can you please state your name and spell the last for the record?
I sure can. My name is Alex Cifuentes, spelled S-I-F-U-E-N to the T-E-S.
Now, Mr. Cifuentes, how old are you?
I'm currently 18. I'm a senior at Colorado High School.
And how did you know the late Mackenzie Brackman?
Well, he was my amazing mock trial coach. I was in mock trial with him for 3 years.
And how did you know Ms. Becker?
Well, Ms. Becker was a teammate of mine on the mock trial team.
And were you and Ms. Becker ever rivals?
No, I wouldn't say rivals at all. In fact, I think Avery and I were pretty decent, good friends. I consider Avery a best friend. Equally skilled teammates, just pushing each other to do the best.
During mock trial, did you and Ms. Becker spend a lot of time together?
Of course, mock trial is super, super time consuming. So we spent a lot of time working on things. Well, I spent a lot of time working on things.
Since you spent quite a bit of time during mock trial, in your perception, did Ms. Becker and Mr. Brackman get along?
Well, based on 3 years of experience with these two, their relationship was never good from the start. From my observation, I mean, Avery would always show up unprepared. She would not do the right procedures that Brackman wanted, and Brackman would get very frustrated, and in turn, Avery would too.
During your time on the team, was Ms. Becker ever demoted from the A team?
Yes. She one time showed up to practice so unprepared. She was tripping over her own words practically. And so Brackman had enough and demoted her to the B team.
Was she able to ever return to the A team?
Yeah, her second best friend Taylor Perkins stepped down so Avery could get back on the team, but that was kind of a cheap move. But yeah.
And after this, was there ever any other major dispute between Ms. Becker and Mr. Brackman?
I would enhance the word major. It was a huge, huge dispute. After the regional practice, the regional tournament, Coach Brackman simply criticized some of the practices Avery had done during the tournament that still got her the win. And Avery, just saying she blew up was an understatement. She got extremely angry.
What happened after this?
Sorry, can you repeat your objection?
Objection, improper character evidence.
Response?
Your Honor, this witness is merely stating their present sense impression of the event, and that was their observation of how the defendant responded. I would say it's not improper character evidence, but rather a simple perception of the event that was currently happening.
Any reply?
Yes, Your Honor. Under Rule 404B, evidence of a crime, wrong, or other act is not admissible to prove a character or character trait in order to show that on a particular occasion, that person acted in accordance with that character trait. Here, opposing counsel is trying to show that because Ms. Becker at the time got very angry with Coach Brackman, that she would go as far to go to his house and murder Coach Brackman in rage, which is improper character evidence under this rule.
Your Honor, may I respond?
Quickly.
This question is merely asking a specific event that leads to establish the relationship between the defendant and Mr. Brackman. It is not used to prove that the defendant was the one who committed the crime, but rather to establish the relationship between the two, the victim and the defendant.
This is a close call, but I will overrule the objection and allow the evidence. Go ahead.
Thank you, Your Honor. I will ask the question again. What happened after their dispute?
Well, Avery, she was visibly upset and she grabbed a permanent marker and stormed out and wrote "Worst Attorney Award" on Mr. Brackman's beloved 1986 Porsche.
Were you there to witness Ms. Becker taking the marker that she used to vandalize the car?
Oh yeah, I was there the whole time. She's standing right next to the easel paper and grabbed the permanent marker and walked right out.
And after this, was Ms. Becker permanently removed from the team?
Ms. Becker was removed from the team. Mr. Brackman didn't push charges, but he was very upset. So yeah, she was kicked off.
Moving on. Now, Mr. Cifuentes, a few weeks after Mr. Brackman was murdered, were you ever contacted by a police detective?
Oh yeah, Detective Markowitz, I believe he called me up and asked me to attend a police interview, and I had received messages from Avery that are slightly concerning. So yeah, I didn't want to lie. So yeah, I did attend a police interview.
Were you also contacted by a private investigator?
Yes, I was. I did not want to talk to the private investigator, but they persisted, so I still didn't though.
During your conversation with the investigator, did you learn that you had been accused of anything?
Objection, leading question.
Your Honor, I can rephrase the question.
Please rephrase. Thank you.
Had you been accused of anything?
I had been accused of a couple things actually. Avery accused me of stealing her phone and giving it to a kid named Blair Rollins. I don't really know where this is coming from, but she accused me of faking texts. Yeah, there was a bunch of accusations that I found quite frankly ridiculous.
Did you know Blair Rawlings?
I mean, I knew he went to our school, but I knew him just as well as every other person on the mock trial team. I certainly wasn't close to him.
Would you have ever stolen Miss Becker's phone?
Look, I wouldn't have stolen anyone's phone, especially Avery's, and especially not for some kid named Blair Rollins.
Coming back to when you were contacted by the police, were you requested to conduct an interview at the police station?
Yes.
And were you asked to bring the phone with those text messages?
Yeah, Detective Markowitz wanted to look at the messages Avery had sent me about Brackman's house.
Did you bring that phone?
Well, no, my phone is quite the brick. It has a battery that doesn't last as long as me watching Bambi and not crying. So yeah, it had a very short battery. I had to plug it in. I was under a lot of stress, and no, I did not bring the phone.
Your Honor, let the record show that I'm directing opposing counsel to a copy that has been previously marked and provided as Exhibit 14. Permission to direct the witness.
All right.
Mr. Cifuentes, can you please direct your attention to what has been previously marked and provided as Exhibit 14? And can you please identify it?
Yeah, these are the messages Avery had sent me about breaking into Brackman's home.
Looking into these messages, did you receive these messages the day Ms. Becker was removed from the team?
Objection, leading question.
Your Honor, I don't believe this is a leading question. It's open-ended. The witness may respond however he wishes. It's not a simple yes or no.
All right, reply.
Your Honor, I feel that the question does call a yes or no response, and it is not open-ended.
All right. I'm going to sustain the objection.
Your Honor, may I rephrase the question?
Yes, you may.
What day did you receive these messages from Ms. Becker?
Oh, I received them the same day that she was kicked off the team after the regional tournament.
And are these the messages? What did she ask you in these messages?
Well, she wanted to get back on the team through my help. Yeah, and that's what pretty much the first part of the messages were all about, getting back on the team.
Did you help her at all?
I mean, of course I did. It was more for the team. As much as I think the team was better off without her. I mean, we did need to win state, and without her, we could have been disqualified. So yeah, I tried to get Avery back on the team.
Upon learning that, did Were you able to convince Mr. Brackman to let Avery back on the team?
Well, based on the messages, no. I mean, obviously Brackman did not want Avery back on the team after what she did to the car. So yeah, Brackman definitely did not want Avery back on the
Objection.
team.
Objection. Move to strike. Assumes facts not in evidence.
Response?
Your Honor, the witness is simply speaking towards after speaking with the victim, their communications with the coach after asking to get the defendant back on the team. I believe that's not necessarily referring directly to this piece of evidence.
Reply?
Yes, Your Honor. Mr. Cifuentes is testifying about Exhibit 14 without it being entered.
I'm going to sustain the objection.
Moving on, Mr. Cifuentes. Have you ever received text messages from the defendant before?
Yes, I have. We text all the time, especially about mock trial.
And these messages came directly from your phone?
Yeah, yes, they did.
And have these messages been altered in any shape or form?
I mean, why would I alter them? Of course they haven't been.
Is this exhibit a true and accurate representation of the messages you received from the defendant?
Absolutely.
Your Honor, at this moment, I would like to move Exhibit 14 into evidence.
Counselor, is there any objection to this?
Yes, Your Honor. I object to hearsay, lack of foundation, best evidence, and as well as authenticity.
Response?
In consideration to the lack of foundation, Your Honor, the witness has laid out that they have received text messages from the defendant before, as well as what day they received the text messages. Under the hearsay, these are statements of a party opponent under Rule 801D.2 and therefore cannot be hearsay. In consideration to authenticity, the concerns counsel has brought up goes to the weight of the messages rather than their admissibility.
Reply?
Yes, Your Honor, these are screenshots of the text, not the original copy. Therefore, to satisfy the requirement of authentication or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. Here, we do not believe that Avery Becker sent these texts. As to the lack of foundation, there hasn't been enough foundation laid to prove that Ms. Becker did send these texts.
Your Honor, may I briefly respond?
Briefly.
In consideration to the issue of duplicates, these messages were taken directly from the witness's phone and therefore cannot be duplicates and are not cell reports, so they do not belong under Rule 103 or 1003.
I'm going to overrule the objection. I find there's an adequate foundation has been laid, and the other objections go to weight, not admissibility. So you may proceed, Ms. Martin.
Thank you, Your Honor. Permission to constructively publish Exhibit 14 and allow the jury to view it briefly for a few seconds.
Permission granted.
Your Honor, may I proceed?
Yes, you may.
Now, Mr. Cifuentes, what text did you receive specifically from the defendant?
Well, I received texts that outlined that after Coach Brackman refused to let Avery back on the team, Avery threatened Mr. Brackman's house by saying, if he's upset about the car, wait till he sees what I do to his house.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Mr. Cifuentes, you claim that you and Ms. Becker were best friends.
Oh yeah, we were really close.
But you never hung out with Ms. Becker other than in mock trial, did you?
Well, mock trial was a lot of our lives, so I don't know why you consider it outside of mock trial. Mock trial was pretty much a prime hangout spot.
In fact, you were jealous of her.
Well, Avery just got a lot of more awards for some things that I consider to be a little less professional. So yeah, there's moments where I was a bit jealous.
You were excited for the larger roles you would receive with Ms. Becker off the team.
Objection, Your Honor.
Wait until she finishes the question, and then I want to take your objection, okay?
Mr. Fuentes, you were excited for the larger roles you would receive with Miss Becker off the team, weren't you?
All right. Now, Ms. Martin, do you have an objection?
Yes, Your Honor. Under Rule 404, evidence of a person's character or character trait regarding whether or not they would be excited about having better roles, I believe counsel is leading to questions asking whether or not the defendant would be, or Mr. Cifuentes would be happy if the defendant was removed from the team or something happened to them. And it is not admissible to prove that in a particular occasion that they acted in accordance with this trait.
Counselor, response.
Yes, Your Honor. Under Rule 404B, evidence is admissible for other purposes such as showing motive. Here, Mr. Cifuentes would receive better roles with Miss Becker off the team, and it was beneficiary to him with Miss Becker off the team. Therefore, this is motive. And we are not trying to prove that there's a particular character trait and that Mr. Cifuentes in the future be acting in accordance with.
Reply?
Your Honor, I do believe that counsel has brought up a character trait of them being jealous and acting in accordance to this jealousy of Miss Becker.
So I'm going to allow it as to, I'm going to allow it, so I'll overrule the objection. Go ahead.
Mr. Cifuentes, you were excited for the larger roles you would receive with Miss Becker off the team.
I mean, wouldn't anyone? Avery often got a lot of good roles, so yeah, I'd be the runner-up. I was pretty excited.
In fact, you were the one who would benefit the most with her off the team.
Probably it's more the team that would benefit the most because we'd have a lot of good lawyers ready to play correctly.
So, Mr. Cifuentes, that is yes to my question.
Absolutely, yes.
Let me now ask you about some text messages you say you received from Miss Becker. Permission to show
Absolutely.
Exhibit 14 on the screen? Mr. Cifuentes, that's Avery Becker's name at the top, isn't it?
Yes, that is Avery Becker's name at the top.
But there's no phone number listed for her name, is there?
Well, my phone is kind of a brick, so a lot of these things that are normally on phones aren't really on my phone, which is, it's a reason I don't have it anymore.
So yes or no, Mr. Cifuentes?
Yeah, I did answer yes, that is Avery's name at the top.
But there is no phone number listed.
Oh, yeah, no, there is no phone number as my phone is kind of a brick.
There's also no date or timestamps indicating when each text was sent or received, are there?
No, but the contents of the messages show directly when this happened, right after she was kicked off.
Mr. Cifuentes, that wasn't my question. My question was about the date or timestamps.
Oh, no, there's no date or timestamps. Once again, my phone's a brick.
Did you take the text that Miss Becker allegedly sent to you seriously?
Well, at the time, I didn't really kind of expect the events that would follow up to be true, but I did kind of see it happening, but no, it was weird.
You didn't take them seriously because Miss Becker never sent these, did she?
Well, no, Miss Becker sent them. It's just the matter of seriousness or not is not really relevant. It's just I responded as I did.
If these texts were real, you would have contacted the police. It was possible your coach house would be broken into, but you didn't do that.
Well, I mean, if you think about it, these messages, as much as Avery had done this before, I didn't immediately think of the worst.
Excuse me, this is a yes or no question, Mr. Cifuentes.
No, I did not contact or warn anyone.
Permission to take Exhibit 14 off the screen. I now want to ask you about the interview you gave to Detective Markowitz. You completely forgot to bring your phone to the police station?
Well, like I said, the battery was dead and it has to constantly be charging. I was under stress. My dad yelled at me. So yeah, I did leave it behind.
So Detective Markowitz never looked at the original copy of these texts, did she?
No, but I offered to bring it in, but it was Detective Markowitz just accepted the screenshots. I was very willing to bring the phone in.
And you have a new phone now, don't you?
Oh yeah, I do.
You got rid of the old phone with the original text on it.
I mean, yeah, the screenshots were acceptable, so it's probably serving as a brick in some construction site.
So isn't it true that the defense has never had an opportunity to see if these texts were real? Yes or no?
No, but the Detective Markowitz verified the screenshots. He accepted them.
I want to ask you now about another student at Colorado High School. Do you know of a person named Blair Rollins?
I mean, I know of them. I'm not close with them.
You were classmates at CHS, weren't you?
Yeah, much like everyone else.
You were aware that Mr. Brackman represented Blair Rollins' father in his criminal trial, weren't you?
I mean, I was aware, yes.
You also knew that Mr. Rollins was sent to jail as a result of Coach Brackman losing his criminal trial.
I suppose so. It's not really in my scope of knowledge. I don't really know that much about it, only the basics of it.
Let's move on to March 5th, 2020. You were at the Fry Shack that day, weren't you?
Oh, yeah. It's a common hangout spot for the mockers, as we call them.
You saw Miss Becker there, didn't you?
Oh, yeah, we did.
You two talked how she should move forward from the team.
I mean, yeah, Avery was upset, and, we tried to cheer her up by telling her that, there's other things to look forward to and stuff like that.
She even thanked you for this advice.
Oh, yeah, like I said, Avery and I were close. As much as I had our slight disagreements, yeah, she thanked me for all that.
So as of March 5th, it didn't seem like Miss Becker had any angry or bitter feelings about mock trial at all, did it?
Well, I don't really know what she was feeling. I just know what happened. I can't comment on exactly how she was feeling. From my observation, she thanked me. That's all I can say.
You played a new game on the defendant's phone right before it went missing, didn't you?
Oh yeah, it was a pretty good time. We played games on our phones.
No further questions.
Redirect?
Yes, Your Honor, only a brief one. Mr. Cifuentes, would you consider you and Miss Becker rivals?
No, not at all. Like I said, Avery was a best friend of mine, so not rivals at all.
And I know this is a hard question to ask, but would you have ever wanted to put Mr. Brackman in any harm?
Look, he's such a great coach, and not only a great coach, but a great person. I don't think anyone would want to put him in harm, especially not me.
Thank you, Your Honor. No further questions.
Recross?
No, Your Honor.
Okay. All right. Thank you. And next witness for the prosecution, please.
Your Honor, the prosecution would like to call Kyle Kuzak to the stand.
All right, you may proceed.
Thank you, Your Honor. Mr. Kuzak, can you please state your name and spell it for the record?
You're on mute.
Mr. Kuzak, I think you're on mute.
My name is Kyle Kuzak, last name spelled Kuzak.
And what is your current job, Mr. Kuzak?
Well, I currently work alongside the Denver Police Department as a crime scene reconstruction investigator, or CSR for short.
Do you have any certifications for your work?
As a matter of fact, I do. I am certified by the Colorado Bureau of Investigation to work as a crime scene reconstructionist.
What types of cases have you previously investigated?
Well, I've investigated many complex cases, some even similar to this case today, such as home invasions, burglaries, and other property crimes, homicides, to domestic violence, fatal accidents, and even armed robberies.
And Mr. Kuzak, how long have you been working in this field?
For over 19 years at this point.
Thank you. Your Honor, considering Mr. Kuzak's state certification and lengthy experience in a variety of different cases, I would like to certify him as an expert in crime scene reconstruction.
Any objection?
No objection, Your Honor.
All right. Mr. Kuzak will be received as an expert in that field. Go ahead, Counsel.
Thank you, Your Honor. Mr. Kuzak, how do you initially approach the process of investigating a crime scene?
Well, while approaching a crime scene, I keep two key principles in mind. The first principle is I assume every case will be going to trial. And then afterwards, when I actually visit the crime scene, I keep details of the mindset for future reconstruction.
And what methods do you generally use to create your reports?
Yes. To create my reports, I use a 5-step process: recognition and collection of the evidence, evaluation of evidence, and then into the hypothesis testing, and finally the reconstruction.
Did you apply these methods to this case?
Yes, I did.
Mr. Kuzak, how did your involvement with this particular case begin?
Well, my involvement in this case began when I personally visited the crime scene. I find visiting the crime scene provides insights and perspective that might otherwise not be provided. Thereafter, I would review all of the police reports in the case, the photographs from the crime scene, as well as the 4 Ring security camera videos.
When you visited the crime scene, what pieces of physical evidence stood out to you?
Most notably, there were scuff marks near the back sliding glass door, a broken plate, an open knife drawer and a missing knife from a knife block, a blood trail leading to the knife, and then finally the victim's body.
All right, Mr. Kuzak, I'm going to ask you a bit about each of these pieces of evidence and how they contributed to your report. Your Honor, let the record show that I am directing the defense counsel to what has previously been marked as Exhibit 18, permission to also direct the witness.
Granted.
Thank you, Your Honor. Mr. Kuzak, do you have this image in front of you?
As a matter of fact, I do.
And do you recognize this photograph?
Yes, it is the scuff marks through the back sliding glass door.
Is this one of the same photographs you used to create your report?
Yes, it is.
Would you say that is it a fair and accurate representation of the crime scene you saw?
Yes.
Your Honor, I ask that this exhibit be moved into evidence.
Any objection?
No objection, Your Honor.
What exhibit number is it again?
Exhibit 18, Your Honor.
18. Exhibit 18 is admitted.
Thank you, Your Honor. Mr. Kuzak, what is this photograph?
Once again, this photograph is of the scuff marks that were found at the crime scene near the back sliding glass door.
And what did you conclude from this photograph?
Well, from using this evidence, I used it within my linear sequential unmasking process, where I try to sequence things and rid myself of any biases I may hold. Using it, I figured out that this was most likely the beginning of the scuffle between the intruder and the victim.
And you also mentioned seeing a broken plate. What did you conclude from this broken plate?
Well, from the broken plate, I concluded that, well,
Objection,
the
Your
scuff...
Honor. Your Honor, I'm not quite sure if we can hear you.
You can't hear me?
I can hear you now.
I'm sorry. Okay. All right. So what's the objection? I'm sorry.
Your Honor, the objection was to leading.
Your response?
Your Honor, I can restate the question.
All right, please restate the question.
Thank you. Mr. Kuzak, did you conclude anything from this broken plate that you saw?
As a matter of fact, I did. From the broken plate, I concluded that the scuffle that began near the back sliding glass door likely moved to the kitchen table and even increased in intensity, and they would there knock the plate off the table.
Did you conclude anything about the open drawer or the missing knife?
Yes. I concluded that the victim was most likely alerted to the intruder's presence, and they went to the kitchen to grab a knife to defend themselves.
What was the outcome of this altercation you mentioned?
Well, the outcome was that they went from the scuffle would begin at the back sliding glass door and move to the kitchen table. The knife would be wrestled away from the victim's grasp by the intruder, and the victim would be stabbed in the back. Following the blood spatters leading to the front door, the victim pulled out the knife and would bleed out on the floor.
Thank you. Based on your observations, what type of activity occurred at this crime scene?
Well, from all the evidence that I gathered, it was most likely that the victim went in for some like a burglary and ended up murdering the victim.
Thank you. And was your work peer-reviewed after you came to this conclusion?
Yes. As part of my 5-step process, my final one, the reconstruction, it is peer-reviewed to make sure that my investigation was both logic and of sound mind.
And Mr. Kuzak, are you aware of the theory that Professor Van Owens deduced from the same crime scene?
Yes, I am.
Are there any discrepancies between his report and your own?
Yes, Professor Van Owens' theory fails to explain the majority of the physical evidence. It fails to explain the scuff marks, the broken plate on the floor, even how the intruder had time to rifle through the knife drawer. It also, Van Owen didn't even visit the crime scene. So I do object to many of his observations.
Thank you, Your Honor, and thank you, Mr. Kuzak. I have no further questions.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes, you may.
Mr. Kuzak, you believe that Mr. Brackman was sitting at his kitchen counter when he received doorbell notifications, right?
Yes, I do.
And no investigation was done by you or anyone on the prosecution to see whether he actually received those notifications, right?
No one here testifying did investigate into that.
But it's your opinion that once Mr. Brackman did receive these notifications, he thought somebody was trying to break into his house, right?
It was, in my opinion, that it was most likely that once the victim was alerted to the presence, that went to the kitchen to
Thank you,
defend
Mr. Kuzak.
themselves.
That's a yes to my question.
The victim did try to go defend themselves.
And Mr. Kuzak, at this point, Mr. Brackman didn't call 911, did he?
Well, someone was entering his house. He probably just made a snap
Mr.
decision
Kuzak,
and went to the kitchen.
My question wasn't who was entering his house. My question was whether he called 911. He didn't, did he?
No, he must have made a snap decision and went to the kitchen instead.
And Mr. Kuzak, when the intruder was moving around to the back side of the house, he didn't run out the front door to call 911, did he?
No, I guess he didn't.
Instead, you, as you said on direct examination, you believe he was frantic and searched around for a weapon to defend himself, right?
Well, I can't say whether or not he was frantic, but it is my opinion that he went to the kitchen to grab a knife to defend himself. Yes.
Now, you reviewed images of the crime scene?
That and all of the evidence while I was there in person. Yes.
And one of these images was the image of the table Mr. Brackman was sitting at, right?
Yes, it was.
Please turn your attention to Exhibit 9. What is this image?
I am pulling it up. Give me a second, please. Exhibit 9, you said? Oh, sorry. I apologize. You were sharing your screen.
No worries. What is this exhibit?
This is in the exhibit of the broken table or the broken plate that was found on the floor.
Is it a fair and accurate representation of the table he was sitting at and the broken plate on the floor?
Yes, they both are accurate.
Your Honor, I move to enter Exhibit 9.
All right, is there any objection?
No objection, Your Honor.
All right, Exhibit 9 is admitted.
So, Mr. Kuzak, you just testified that Mr. Brackman was looking for a weapon to defend himself, yet it's your belief that Mr. Brackman did not grab the scissors that were right next to him at the table. Isn't that right?
I believe that he went to the kitchen instead. That is my expert opinion.
So as he's moving around to the kitchen, you believe that the intruder has now made their way to the back of the house, right?
Yes, I do.
And in your opinion, the intruder and the victim never saw each other between a glass door. Isn't that right?
Well, it's actually in my opinion that the victim did see the intruder. That's why they went to the backsliding glass door to confront them near the scuff marks.
So in your opinion, the intruder attacked the victim because the intruder saw the victim inside the home.
Well, I can't say whether or not the victim saw. The intruder saw the victim. I just know that the victim likely went to the backsliding glass door to confront the intruder.
So once entering this glass sliding door, you said there was some sort of fight, right?
Yeah, it is. I believe a scuffle broke out there.
And please turn your attention to Exhibit 18. These scuff marks, these black marks on the floor, they justify your claim, right?
I believe they are a piece of physical evidence that would notify myself to the scuffle that broke out.
And isn't it true in your witness statement that you say these scuff marks were created by two people?
That's what I believe was likely. Yes.
Mr. Kuzak, please turn your attention to what has been marked as Exhibit 1. What is this image?
This is a picture of the victim's body that was found near the front door of the residence.
Is it a fair and accurate representation of what you saw at the crime scene?
Yes, it is.
Your Honor, I move to enter Exhibit 1.
All right, any objection?
No objection, Your Honor.
All right, Exhibit 1 is admitted.
Mr. Kuzak, looking at Mr. Brackman's feet in Exhibit 1, isn't it true that he wasn't wearing shoes on the day he was murdered?
Well, I can't say whether or not he was wearing shoes during the day he was murdered. All I can say is that he was not wearing shoes while he was murdered.
So now moving back to Exhibit 18, Mr. Kuzak, you just stated that these scuff marks must have been created by two people. Isn't that right?
Yeah, over the course of my investigation, I believe that it would be likely that that could have been what happened.
So isn't it true that the intruder and Mr. Brackman didn't create these scuff marks?
It's, in my opinion, the intruder and Brackman could have created them. And if, I guess, the intruder was wearing shoes, the intruder must have been the one to make the scuff marks.
Now you believe that this fight went over to the kitchen counter where, over to the kitchen table where the intruder stabbed Mr. Brackman in the back, right?
Yeah, that was the final outcome of that altercation.
And Mr. Cusack, after the intruder fled the scene, in your opinion, Mr. Brackman pulled the knife out of his own back. Isn't that right?
I mean, I did follow the blood trail leading up to the body. Yeah, that's what I believe happened.
Now, Mr. Cusack, in your spreadsheets and your flowcharts that you mentioned on direct examination, you conducted interviews of different suspects, right?
Yes, I did.
And one of those interviews was with the defendant, Avery Becker, right?
Well, the information I gleaned was from another investigator's interview, but yes, I do have information from that interview.
And isn't it true, Mr. Cusack, that Detective Markowitz was not able to get an interview with the defendant, Ms. Becker?
Yes, that is true.
But you had access to your own interview with the defendant. Isn't that correct?
Well, I'm a crime scene reconstructionist. I'm not a police officer, so I only had access to the information
Sorry,
that
Mr. Cusack, that wasn't my question. My question was, you included this information in your spreadsheet and you had access to that information. Yes or no?
Oh, yes, I had access to other interviews. Yes.
And Mr. Cusack, you made a witness statement in this case?
Yes, I did.
And in that statement, you swore to include everything you deemed relevant to the case, correct?
Yes, I did.
And up until this morning, you had an opportunity to amend that statement if any new relevant information surfaced, right?
Yes.
But isn't it true that, you didn't deem it relevant enough, Mr. Cusack, to include the only interview with the defendant, Avery Becker?
I was not able to get any information from that interview. No.
Your Honor, I have no further questions.
Redirect?
Yes, please, Your Honor, briefly. Mr. Cusack, does your job with crime scene reconstruction entail working with evidence beyond what is found at the crime scene?
Unfortunately not. While I do have sometimes access to other evidence at the crime scene, it's to create a reconstruction of what occurred at the crime scene, not the extraneous activities around the crime scene.
Thank you, Your Honor. I have no further questions.
Ross?
No, Your Honor.
All right. So this witness may be excused, and then we'll let's take a minute here, and I want to turn these shades on. So, and then we'll have the next witness for the prosecution. All right, are you ready now for the next witness for the prosecution?
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz to the stand, please. Good afternoon, Detective Markowitz. Could you please state your name and spell your last for the record?
Jordan Markowitz, Markowitz.
And what is your profession, Detective?
I'm a homicide detective with the Denver Police Department.
How long have you worked with the DPD?
13 years.
And how long have you worked as a detective?
7.
Have you received any special training to assist you in your profession as a homicide detective?
Yes, I have a certification from the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
And what did you learn through this training?
Through this training, I learned how to obtain and interpret, as well as download records from cell phones, use analysis systems such as Cellebrite, and interpret, obtain, and analyze cell phone tower data.
Do you frequently use this special training in the course of your work as a homicide detective?
I have downloaded information from hundreds of phones, and I have used cell phone tower data in over 50 cases.
Your Honor, I'd like to qualify Detective Jordan Markowitz as an expert in the areas of forensic investigation, cell phone technology, and forensic data recovery under the Rule 702, based on her abundant experience, skill, and knowledge in those fields, which is what allows somebody to be qualified as an expert under 702.
All right. Any objection?
Yes, Your Honor, may I have a brief word here?
Yes, you may.
Detective Markowitz, your only training in forensic data recovery was from a 3-day training course, correct?
I completed a 3-day training course from the American Academy of Law Enforcement, and I frequently use these
Your
training.
only training, correct? The 3-day course?
That would be my only training officially from the American Academy of Law Enforcement.
And you never used your forensic data training in the 50 cases you just mentioned.
I'm sorry, can you ask the question?
You never used your forensic data training in the 50 cases you mentioned. You only used your cell tower training.
Well, at points
Objection, Your Honor. This statement is not included in the witness's witness statement. In their statement, it reads, I also use cell tower data on a regular basis, and I have obtained and interpreted cell tower data in over 50 cases. I believe what the opposing counsel is asking qualifies as unfair extrapolation from the witness's witness statement, as it contradicts a statement that they made in their statement.
Response?
Yes, Your Honor, that is a great point from opposing counsel. What I'm trying to prove is that Miss Detective Markowitz never used forensic training in her experience and therefore should not be entered as a witness for forensic data recovery and forensic investigation. She has not included any evidence or any testimony in her witness statement that she has the knowledge, skill, experience, or training to testify as an expert in these fields.
Permission to respond, Your Honor. Excuse me, sorry, I didn't quite hear that.
Yes, please. Go ahead.
Thank you. In the statement, I believe that it is at least implied, if not directly stated, that Detective Markowitz has used cell tower data on a regular basis. The implication from that is that thus she used the training that she received to download that cell tower data, in addition to, interpreting cell tower data. I believe that the implication in the statement, as well as, essentially the sort of basis of Detective Markowitz's statement, is that she does use her training in the course of her work as a detective.
Your Honor, may I briefly respond?
Yes, you may.
Detective Markowitz has not testified to any of this, and having opposing counsel testify what she means by this is unfair, and an unfair objection to be testifying what the witness can have knowledge on or what she does have knowledge on, and reading it directly from her statement is hearsay in this case because this is an out-of-court statement being used for the truth of the matter asserted. So to use that in an objection is unfair objection.
Permission to respond, Your Honor.
No, permission denied. I'm just going to, I'm not going to rule, but I am going to read something to the scoring panelists. You, the scoring panelists, are the sole arbiters of this dispute. Based upon your own individual observations, good faith judgment, and consistent with the intent of the judicial process, you may decide that A, there was no extrapolation, or B, the statement was not unfair extrapolation, or the question did not ask for unfair extrapolation, as it was not material, or the statement was unfair extrapolation, or the question was asking for unfair extrapolation, as it was material. The ultimate decision is in the discretion of each of you, individual scoring panelists. Consistently with your decision, you may award one or more points, deduct one or more points, or take no action at all with respect to any of the parties involved. If you determine that there was no unfair extrapolation or that there was no question asking for unfair extrapolation, you may deduct one or more points from the objecting party if you believe that the objection was not made in good faith, was improvident, or was poor sportsmanship. Your decision is final. Now, let's proceed with the cross-examination.
Yes, Your Honor, I have one final question. Nowhere in your statement do you say you used forensic data recovery in these 50 cases, do you?
I do not say I used forensic data recovery directly. I used cell phone data technology to interpret events.
Your Honor, then I raise the objection. I do not object to her being entered as an expert witness in cell phone technology, but I do to object to her expertise in forensic data recovery due to she has not used this in the field and that her only training is from a 3-day training course. And she does not exhibit the training, skill, experience, or education pursuant to Rule 702 and should not be tendered as an expert in this field.
All right, briefly, do you have a response to that?
Yes, Your Honor, I do have a response to that. In testimony in court today, Detective Markowitz did testify to the fact that she often uses things that she learned through that training in the course of her work as a homicide detective. I believe that statement that she made does justify her qualification under 702.
All right, what I'm going to do is I'm going to allow this witness to testify as an expert in all the areas in which she was offered. And I think the objections go more to weight. So continue, Counselor. And I'm sorry,
Thank you, Your Honor.
I said that you may proceed with your cross-examination. It was really what ear of the witness. I'm sorry about that. Go ahead, Counselor.
Thank you, Your Honor. Detective Markowitz, would you describe for the jury how you became involved in this case?
Yes. I was called to the scene after a motorist noticed the victim lying on his porch, and paramedics were called, after which I was called and arrived on the scene at 14:20 hours.
And when you arrived at the scene, did you immediately observe Mr. Brackman's wound?
Yes, I did.
Were you able to recover any security footage from Mr. Brackman's home?
Yes, he had a Ring doorbell, from which I downloaded video footage of an intruder entering his home wearing a Halloween mask, hoodie, and gloves.
Thank you, Detective. And did you further investigate Brackman's cell phone?
Yes, I did. I downloaded a large amount of calls or of texts and emails off of it.
Did you observe any significant patterns in the messages that you investigated?
Yes, it appeared that he had a lot of contact concerning something called mock trial.
And did you further investigate that affiliation?
Yes, of course. I follow up on anything that could be a lead. And so I contacted the mock trial team that he coached at Colorado High School.
Who on the team did you contact first?
A student named Alex Cifuentes.
And did you interview Cifuentes?
Yes. In our initial phone call, Cifuentes told me that they had received several text messages.
Your Honor, hearsay.
Response to the hearsay objection?
This statement is not qualified under hearsay. It's not offered for the truth. It's simply offered to show the course of this detective's investigation into this crime.
Response?
Your Honor, I argue this is being used for the truth of the matter in accordance with Rule 801C2. She is explaining what happened in the conversation and therefore is explaining the exact contents and not showing the progression of her investigation, rather what happened in the single conversation.
I agree. Sustained.
Detective Markowitz, did you, excuse me one moment, I lost track of my line of questioning. Detective Markowitz, were you able to interview Cifuentes at all?
Yes.
And what did you learn through the course of this interview?
I learned that Cifuentes had received several texts from a student who had reported that they were going to break in and trash the victim's home.
Objection, Your Honor. Foundation and hearsay. Again.
I would like a brief clarification on the foundation objection.
I thought it was a hearsay objection.
Oh, I believe counsel also objected on the issue of foundation.
Yes, Your Honor. The foundation has not been laid how this conversation took place. I argue if it took place through them speaking to each other, then this would be hearsay because it is being used for the truth of the matter asserted.
Again, I do not believe that this is offered for the truth. Rather, it is offered to show the course of the detective's investigation, the course of her reasoning. Again, I don't believe that under 801c2 it counts as hearsay, as it isn't being offered for the truth. It's being offered to show the course of this investigator's investigation.
All right, I'll allow it. Overruled.
Thank you, Your Honor. Would you like me to repeat the question, Detective?
No, just move on. You have
Oh,
5
okay.
more minutes.
Appreciate it. After your investigation of the Cifuentes lead, did you contact Avery Becker?
I attempted to get an interview with Avery Becker, but was informed by their lawyers that I would not be able to.
Objection, Your Honor. Under the Fifth Amendment, Ms. Becker has the right, my client has a right to deny an interview. So to say that she denied this interview and insinuate that she has something to hide is against her Fifth Amendment right.
Excuse me, Your Honor, we can't quite hear you. I apologize.
Do you have a response to that
Your Honor, this is simply a factual question. It doesn't go towards any form of Avery Becker has something to hide. It's simply a factual question about the course of this officer's investigation.
All right. I will, you can argue that, and I'll overrule the objection. Go ahead.
Thank you, Your Honor. Did you obtain a search warrant for Avery Becker's cell phone?
Yes, though I was informed the phone was lost around March 5th.
Were you able to obtain any cell data at all for Avery Becker?
Yes, I obtained call detail records.
Detective, would you briefly explain what a call detail record is for the jury?
Yes, it's basically a recording of the interactions between a cell phone and the cell towers nearby.
What kind of information can be obtained through a CDR?
This can determine or tell whether or not the interaction was a call or a text, the duration of the call, whether or not it was answered, but more importantly, which cell tower it interacted with and which antenna.
Under normal circumstances, do cell phones connect with the nearest cell tower?
Yes.
Moving back to the specifics of this case, did you notice any important points while you were reviewing Avery Becker's CDR data?
Yes. On the day of the murder, they had received several calls from another CHS student, Taylor Perkins.
And based on the duration of those interactions, were any calls answered?
No.
Would you direct your attention to the diagram previously marked as Exhibit 16?
Yes.
And would you describe the contents of this diagram for the jury?
This is a diagram I made in the course of my investigation.
And is the exhibit a fair and accurate representation of the diagram you created?
Yes.
Do professionals in your field regularly create such diagrams to help them in the course of their duties?
Yes.
Your Honor, I'd like to ask you to admit Exhibit 16 into evidence, please.
Is there any objection to that?
Yes, Your Honor, I have a few objections. First, to hearsay, there are little black pins with names on it, which are out of court statements being used for the truth of the matter asserted. Also, there is a red line that depicts a probable route that Detective Markowitz believes Miss Becker took. And so this route itself is an out-of-court statement being used for the truth of the matter asserted. It also, this line is speculation, and she does not know if Miss Becker took this route and will testify herself that this is just a probable route. So entering it into evidence would be more unfairly prejudicial because Miss Becker didn't take this route. Further, you heard Miss Detective Markowitz explained that Ms. Becker lost her phone on March 5th. So these cell tower records are not relevant in today's case because Ms. Becker didn't have her phone. So they do not show anything about where Ms. Becker was at this time.
Your Honor, under 8036, this is a record of a regularly conducted activity performed by police detectives in the course of their investigations. Further, this evidence is relevant. The fact that Avery Becker, or the idea that the notion that Avery Becker did not have their phone on them at the time of the crime in question is not a stipulated fact in today's case, and thus is a matter under argument. This fact, I believe, is extremely relevant to the case at hand.
Reply.
Yes, Your Honor. This is a fact. Detective Markowitz explained earlier in her testimony on direct examination that Ms. Becker had lost her phone. She also believes that Ms. Becker lost her phone by testifying it today in court. And so therefore this statement and this saying this line is the line she took would be speculation and would not be admissible.
Your Honor, permission to respond.
Well, permission denied. I'm going to overrule the objection, and I want Ms. Seaman, you to make those. You can make those. Okay.
Yes, Your Honor.
So please proceed. You have about 2.5 minutes left in direct exam.
Thank you, Your Honor. Ms. Markowitz, can you describe to the jury what this diagram signifies?
Yes, this records the interactions of Becker's phone between the time of 12:47 and 1:17, and using the chronological order of these interactions, it approximates the location.
And what does your diagram of possible locations demonstrate, Detective Markowitz?
It demonstrates that it is highly likely that between the time the first call was placed at 12:47 to the time the last call was placed at 1:17, Avery Becker took the most direct route from their house to the victims. After 1:17, no further interactions are recorded, indicating that the phone was shut down, put in airplane mode, or destroyed.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. May I proceed?
Yes, you may.
Detective Markowitz, you took photos of the crime scene, correct?
I did, yes.
And I'd like to turn your attention to exhibits 1 and 4. These are fair and accurate. Are these the photos you took of the crime scene?
Yes, those are.
And are these fair and accurate depictions of what you took?
Yes.
The defense offers exhibits 1 and 4 into evidence.
Any objection?
Aside from the fact that I believe that the defense has already entered exhibit 1 into evidence, I have no objection.
Okay. Exhibit 4 will be admitted, and exhibit 1 is already admitted.
My apologies, Your Honor.
Go ahead.
Now, Detective Markowitz, in exhibit 1, the defendant's hand is above his head, correct?
That is correct, yes.
In exhibit 4, his hand is to the right of his head.
Yes.
Someone moved the body.
That could be a possible conclusion.
Now, you also took images of blood drops at the scene, didn't you?
I did, yes.
But you lost these images.
They were unfortunately corrupted, but I think, as we all know, technology can be fickle.
And the defense never had a chance to analyze them.
No, as they were corrupted, that was not available.
You also don't know what time Mr. Brackman died.
No, I do not believe anyone does.
And on direct examination, you said Alex Cifuentes gave you the biggest lead in this case.
I obtained a lead from Alex Cifuentes.
He sent you screenshots of an alleged text message conversation.
Along with their interview with me, and I believe they're testifying here today of this interaction.
And these were not the actual copies of the phone. You never reviewed the actual phone, did you?
No, they weren't able to bring their phone to the interview, which is natural. I mean, it's a police interview. People get nervous.
You don't know if these text messages had been doctored or not.
I do not know for absolute certain, but I do have the word of Alex Cifuentes.
You also reviewed CDR records of Avery Becker's phone.
I did, yes.
But those only track where the phone is, not who has the phone.
Well, as they are cell phone records, yes.
And you said yourself that Miss Becker lost her phone on March 5th.
I was informed that Miss Becker lost her phone March 5th.
So if Miss Becker didn't have her phone, these cell records don't matter, do they?
I think I was informed, like I said, that Avery Becker had lost her phone, but I would say that in the case of her actually not having the phone, yes, they would not matter, but whether or not the phone was lost is...
Now, I'd like to bring your attention to Exhibit 16, which has already been entered into evidence. To the left of Miss Becker's house, that says Rollins' house, doesn't it?
Yes, it does.
And that's Blair Rollins' house.
that would be Blair Rowland's house, yes.
And if Blair Rollins had Miss Becker's phone, he would have taken a similar route as Miss Becker to Mr. Brackman's home.
I can't say that for certain, but
You're
they
an
do
expert
live
witness.
close together.
You're an expert witness in this field, though, aren't you?
Yes, I mean, the route could be similar.
And you never investigated Blair Rollins, did you?
I do believe I have substantial evidence concerning other suspects.
But you never investigated Blair Rollins.
No,
And you're aware that you're aware that Mr. Brackman is a criminal offense attorney.
I am, yes.
And you consider that the suspect could be a possible disgruntled ex-client.
It was one of my first considerations, but I have many first considerations, and I look at those considerations and I follow evidence, and I found evidence in another lead.
But you never investigated Jonathan Rollins, Blair Rollins' father, did you?
No,
And Jonathan Rollins had Mr. Brackman as his criminal defense attorney, and he lost that case, didn't he?
yes,
And are you aware of an audio recording involving Blair Rollins' father, Jonathan Rollins, and Mr. Brackman?
yes.
Your Honor, permission to enter Exhibit 22, which has been stipulated as authentic under stipulated fact number 4 by both parties in this case.
Yes, all right.
And the defense moves to enter this into evidence.
Okay. Response, any objection?
Yes, Your Honor, I do object. Under the grounds of hearsay, this is an out-of-court statement offered for the truth and thus is not admissible.
Response?
Yes, Your Honor. Under Rule 8032, this is an excited utterance and therefore is an exception to hearsay. It also, under 8033, it shows Jonathan Rollins' then existing mental, emotional, and physical condition and his motive to get back at Mr. Brackman. As you listen to this tape, you can hear him say he'll get back at Mr. Brackman. So these are both exceptions to the hearsay rule.
Well, I am going to sustain the objection. I think it's inadmissible hearsay. It's a close call, but it's inadmissible hearsay.
Now, Detective Markowitz, you knew that Blair Rollins hated Mr. Brackman.
I suppose that could be said, yes.
But you never interviewed and you never investigated him.
I don't believe anyone has interviewed Blair Rollins.
Exactly, because you honed in on one suspect, didn't you?
I followed evidence. I
No
followed strong evidence in a lead.
No further questions, Your Honor.
I think you have a minute or so remaining, but do you want to have redirect examination?
Yes, Your Honor, I do have a brief redirect, actually. Detective Markowitz, why did you choose not to investigate Blair Rollins?
I had evidence. I had strong evidence, physical evidence, evidence in another lead, in the lead of Avery Becker, and that's why.
Thank you, Detective. No further questions at this time, Your Honor.
And you have less than 2 minutes remaining, but do you want to do recross?
No, Your Honor.
Okay. This witness will be excused. And now does the prosecution have another witness, or is the prosecution resting?
The prosecution rests at this time, Your Honor.
All right. Do you have any witnesses?
Yes, Your Honor. The defense calls Avery Becker.
All right, you may proceed.
Good afternoon, Ms. Becker. Please introduce yourself to the jury.
Hi, my name is Avery Becker, Becker.
Why are you here?
I'm here because they are trying to accuse me of murdering my own mock trial coach, and I promise you that I would never do anything like that to Coach Brackman.
Now, there's been a lot of testimony about your relationship with Mr. Brackman. Please tell us how that relationship actually was.
Coach and I didn't always get along 100% of the time. We did have our disagreements, but in the end, we needed each other to do well in mock trial.
Was there respect within your relationship?
Yes, of course there was. Coach always gave me really good roles.
What roles did he give you?
Last year, our case was pretty simple. It was about these old people arguing over their mother's will. And then there was the corgi dog that the mother always dressed up. I was the one that directed the mother's nurse, and I crossed her doctor.
Objection, Your Honor. Relevance as to the information about last year's mock trial case. I believe that that does not go towards the actual relationship between Mr. Brackman and the defendant, and thus would be irrelevant under 402, or rather 401. I apologize.
Counselor, response.
Yes, Your Honor. Under Rule 401A, testimony is relevant if it makes a fact more or less probable. Her testimony about the case last year is merely laying foundation about the roles she received and if they were good roles, and explaining why they were the best roles to get on the team.
Any response, Ms. Faulkner? Faulkner, sorry.
I don't believe that this has the tendency to make any fact more or less probable than it would be without the evidence. And I also don't believe that this fact is necessarily of consequence in determining the action of the jury today in court.
I'll allow it as some background. So go ahead, Counselor.
Ms. Becker, were these good roles?
Yeah, they were the best roles. Coach always liked to give me the experts in the case.
Now let's talk about regionals of last year. What happened prior to this tournament?
Prior to the tournament, Coach and I got in another little disagreement. It really wasn't that big of a deal. It was on my work ethic. He couldn't understand how I didn't need to put in a lot of effort for mock trial. And so—
Objection, Your Honor. Lack of personal knowledge. I believe that would be under Evidence Code 602. The witness cannot have personal knowledge to exactly what Brackman was feeling. They can testify to their opinion, but I believe that at the moment, Ms. Becker is testifying to the exact feelings of Mr. Brackman.
Yes, Your Honor. Under Rule 701A, a witness can have testimony if it is rationally based on their own perception. Ms. Becker has been on mock trial for 4 years. She has known Mr. Brackman for 4 years, has been part of these roles, and therefore can testify about what happened in this situation.
So ask the question again, and my ruling is going to be you can't, Ms. Becker, testify as to what someone else was feeling, but you can testify to your observations and your discussions with the deceased. So go ahead, Counselor.
And so after your disagreement, what happened?
Well, Coach demoted me to the B team.
And what happened after that?
Taylor Perkins, she's my best friend. She didn't really like mock trial that much. And so she stepped down and I was able to get back on the A team.
And how'd you do at regionals?
We did really, really well. We actually won and it was so incredible.
How'd you do?
I did pretty good. I got the Best Attorney Award and the Best Closing Award, which I was really proud of.
And after this, how was your relationship with Mr. Brackman?
Oh, our relationship got so much worse. Coach was so angry that I had won any awards at all.
Objection, Your Honor. Again, under 602, lack of personal knowledge, witness can testify to her observations under 701, but cannot testify to the personal feelings of Mr. Brackman towards her.
Response?
Yes, Your Honor. She was part of this situation and could see how angry Mr. Brackman was at her. She will testify later about how he humiliated her in front of the whole team. He wouldn't humiliate her unless he was very angry. And so therefore, she is testifying on her own personal knowledge and her own observations at this time.
Right. Response? Reply?
Your Honor, my objection stands, I believe. Witness cannot testify to Mr. Brackman's personal feelings. She can testify to her observations of those personal feelings, but it appeared to me that she was testifying to, the exact contents of his feelings towards her.
All right, Counselor, you can ask a question, and Ms. Becker, you may testify as to your observations and thoughts, but not as to his feelings. Okay, go ahead.
Ms. Becker, what were your observations of how he felt after the tournament, and what is your opinion on what you observed at that time?
Well, based on how the whole conversation went down, he appeared really angry at me because He humiliated me in front of the whole mock trial team and told everyone that I didn't deserve those awards. And the only reason that I ever just won them was just because I looked good.
And how did you respond to this?
I was so humiliated. It was really embarrassing, and I admit that I was upset, and I just wasn't thinking.
And so what'd you do?
I took a dry erase marker and I walked out of the classroom because I didn't want to be insulted anymore, and I just wasn't thinking, and I wrote on his car, and I never should have done that, and I'm so sorry for what I did.
How did he respond to this?
He walked out and he yelled at me and kicked me off the team.
Did you try to apologize?
Yes, I tried to apologize many times. The next day, I knew that what I had to do, and so I went to his office and tried to apologize to him in person, but I wasn't able to. And then I tried to text him, but he never responded. Now I'll never be able to apologize because someone murdered him.
Now let's talk about March 5th. What did you do that day?
Well, Taylor and I were with each other a good chunk of the day. I couldn't go to mock trial practice anymore, so we hung out together.
Where'd you go?
Well, we went to the Fry Shack and we went to the mall.
Did you see anyone you knew at the Fry Shack?
Yeah, I saw a lot of my old mock trial teammates there, including Alex Cifuentes.
Did you hear Mr. Cifuentes' testimony today?
Yes, I did.
And do you agree with his characterization of your friendship?
Absolutely not. We are not friends. I don't know why he thinks that we are.
Did you hear his testimony about text messages you allegedly sent him?
Yes, and he's lying because I did not send those text
Objection, Your
messages.
Honor. Speculation and also lack of personal knowledge. I don't believe the witness can testify to Mr. Cifuentes' lying. I also actually believe that it is inadmissible as character evidence under 404A1 because it is shown to offer, or it offers, evidence that perhaps Alex Cifuentes has a personal trait of lying and that he might have acted in accordance with that trait.
Response?
Yes, Your Honor. Ms. Becker is the defendant in today's case. She has the right to defend herself against false claims. She testified that she never saw these text messages, so it's a logical conclusion that Mr. Cifuentes is lying about them. She has the right to say that because she is defending herself in a murder trial. She has been accused of something else, and in response to the improper character evidence under Rule 403 or 404, excuse me, we are not going to show that Alex Cifuentes lied on one time and lied in accordance on a different occasion. He is lying here in court is the observation in the testimony today because Ms. Becker never sent these text messages.
Your Honor, I believe that to begin with, Avery Becker is not defending themselves in court today. They are testifying for their defense team, but they are not defending themselves. Further, counsel did not respond to the objection of character evidence as to Mr. Cifuentes' character for or for not lying. Simply because Ms. Becker believes that she did not send these text messages doesn't justify the statement that Alex Cifuentes is or is not lying.
I'm going to overrule the objection. This is the defendant, and you will be given appropriate leeway on cross-examination. Go ahead,
Your Honor.
Counselor.
Can you please explain what your thoughts are on these text messages?
Absolutely absurd because I did not send those text messages. I don't know where Alex got those text messages, but they did not come from me.
Now, did you have your phone with you the whole time at the Fry Shack on March 5th?
No, I didn't. Well, I gave my phone to Alex to play video games, and that's the last place I saw my phone.
And when did you realize it was missing?
The next morning on March 6th, I couldn't find it anywhere.
And just to clarify, where was the last time you had it?
Fry Shack.
Now, after realizing it was missing, what did you do?
Taylor and I skipped school to go find it. It really wasn't that big of a deal because we were with each other the whole day.
Where did you look for your phone?
We basically went and retraced our steps. We went back to the Fry Shack and we went back to the mall, and we tried to call and text my phone many, many times.
Did you ever find it?
No, we figured it was dead or stolen because it would automatically go to voicemail whenever we tried to call it.
Now, who would get the roles you lost if you weren't on the team?
Based on what I observed in mock trial practice, I think Alex Fuentes would definitely
Objection, Your
get my
Honor. I
roles.
believe this is under Rule 403. This is potentially should be excluded. Relevant evidence may be excluded if probative value is outweighed by prejudicial effect. I believe that this statement has a prejudicial effect, and thus should be excluded under Rule 403.
Response?
Yes, Your Honor. Under Rule 403, the court may exclude relevant evidence if its probative value is substantially outweighed by unfair prejudice. In this case, the probative value of showing that Mr. Cifuentes would get the roles that Avery Becker had lost by her not being on mock trial, its probative value is farly outweighing any prejudice and therefore is admissible under Rule 403.
I believe that this evidence is more prejudicial towards Alex Cifuentes than it is probative to show any potential, thing that Avery Becker did that might be relevant to the jury's decision today.
May I respond?
I'm going to overrule the objection, and I find that it's a close call, but that the evidence is more probative than prejudicial. Go ahead, Counselor.
So who would get your roles if you lost them?
Based on what I saw in mock trial practice, Alex would definitely get my roles.
Who was Blair Rollins?
Blair was a kid at my old high school, CHS. He was my classmate.
Did you know him?
A little bit. I knew a few things about him, but we weren't friends.
Did he have a reputation in the community?
Yes, he had a reputation in the CHS community for absolutely hating Coach Brackman.
And why was that?
Mainly because Coach Brackman represented Blair's father in jail, and Mr. Brackman lost that trial, and Blair's father got sent to jail.
Now I'm going to ask you a few more questions. Have you ever been to Mr. Brackman's home?
No, I've never been to his home. I have no desire to know where he lives.
Did you kill Mr. Brackman?
No, absolutely not. I did not kill my mock trial coach. I don't know why this is happening to me. I must be being framed. I did not do it. I don't know who killed my mock trial coach.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor.
Okay.
Good afternoon, Ms. Becker. Good to talk to you. So during your time in mock trial, you didn't get along with Coach Brackman?
No, we didn't always see eye to eye on things.
And Brackman said that you didn't put in the work.
Objection, Your Honor. Hearsay?
Your Honor, permission to respond?
I'm sorry. I'm sorry. I don't have this on mute, but it appears you can't hear me. I'm sorry. I have to speak up.
Yeah.
Go ahead.
Your Honor, this statement is not offered for the truth, but rather to establish the relationship between the defendant and the victim in this case. The statement is offered to establish the effect on the defendant, which goes towards their state of mind or motive as well.
All right. It was Ms. Seaman's objection, right? Go ahead, respond. Do you want to reply?
Yes, Your Honor. I argue that this is being used for the truth of the matter asserted to show negative traits of Ms. Becker. And so by making these statements and saying what Mr. Brackman said, it is being used for the truth of the matter asserted to show bias against Ms. Becker and to create a negative image of her.
I will allow the testimony, so I will overrule the objection. Go ahead.
Thank you, Your Honor. Would you like me to repeat the question, Ms. Becker?
Yes, please.
Certainly. Brackman said that you didn't put in the work.
I just couldn't understand that mock trial came so naturally to me, and I really didn't need to put in that much work. See, I crossed the doctor last year, and he was a very predictable expert, and so I didn't feel like I
You
needed
felt
to.
like Brackman never gave you any credit for anything you did.
Well, he did have a lot of us rewrite our scripts for him, but it wasn't just me. It was a lot of kids
You
on my
felt
mock
that
trial
Brackman
team.
never gave you any credit for anything you did, Ms. Becker.
Well, that's true, but it happened to a lot of my teammates too,
And
not just
you
me.
felt like Brackman hated you.
Well, he wasn't always very nice to me, so sometimes when he would criticize me, of course I would get a little upset and think that that was probably the case.
Ms. Becker, you felt that Mr. Brackman hated you.
Yes, I did, just based on his actions and how he acted towards me sometimes.
And you argued at almost every practice last year?
We didn't always see eye to eye on certain things, so
And you argued at almost every practice last year for that reason?
Wait a minute. Stop that. Ms. Seaman?
Yes, opposing counsel is interrupting my witness and not allowing her to finish. She's badgering the witness.
All right. Now, this happens all the time. In real life, we interrupt. We can't in trial. So you must wait, Ms. Becker, till the question is completed before you start your answer. And Ms. Faulkner, you must wait until she completes her answer before the next
Of course,
question.
Your Honor.
So you can start again.
Yes. You argued at almost every practice last year?
We didn't always see eye to eye on some things, so sometimes, yes, things would come up.
And so you argued at almost every practice last year?
Again, we did have our disagreements, so sometimes, yes, we would argue.
At almost every practice last year?
Sure.
He called you lazy?
Yes, he did. It's because he couldn't understand that mock trial just came so easy to me.
And you told him that he wouldn't know a good cross if it hit him over the head.
That was one of my funny quits, yes.
About a month before regionals, Brackman removed you from the A team and sent you over to the B team.
Yes, he did. Again, it was because of my work ethic.
And you were upset.
I was a little upset because, I mean, I could cross the doctors so well, and I had a real knack for crosses and closings, so I couldn't understand why he wanted to demote me.
You believed that the B team was full of losers?
Well, I mean, they didn't win state, so by definition, or regional, so by definition, they are losers, and they only ever took the scripts that the coaches wrote for them. I mean, how are we supposed to be successful on our own if someone does all the work for us?
Ms. Becker, let's discuss your relationship with some of the other students in mock trials. So you and Taylor Perkins were friends.
Yeah, we were.
And you joined mock trial to hang out with Taylor and play on your phones.
Yeah, Taylor and I would text each other from across the room when mock trial would get a little monotonous sometimes.
Taylor quit the A team in order to help you restore your position when Brackman demoted you before regionals, am I correct?
Yeah, she didn't really like mock trial that much, and she felt bad for the A team.
And your team did well at regionals.
Yeah, we won. It was so incredible. It was really, really something.
And at practice after the regionals, Brackman and you got into an argument.
Yeah, we did.
He said that you didn't deserve the best attorney award.
Yeah, that's true. Honestly, I really thought he was going to get behind me and support me.
And he said your closing statement was just lucky.
Yeah, I had a tendency to just make up the closings on the fly, but I especially liked the rebuttal of closings because I could take the other team's argument and just rip it to shreds. It was really fun.
He told you that you would cause the whole team to look bad at state if you didn't put in a lot more work.
That is what he said, yeah.
And so you called him the worst coach in the state.
I admit that I did say some things that were not necessarily true. I knew that even though our argument was getting a little rocky, I knew that he was a good coach and he knew how to get us to the top.
Ms. Becker, you called him the worst coach in the state.
I did call him the worst coach in the state, but I didn't mean that. It was just in the heat of the moment.
You were angry.
I was upset. He humiliated me in front of my entire mock trial team and told me that I didn't deserve those awards, and I was so shocked.
You stormed out of practice.
I didn't want to be insulted anymore, and I just wasn't thinking. I never should have taken that dry erase marker. I am so sorry.
I'd like to move on to the day that Brackman was murdered, March 6, 2020. You claim that you noticed your phone was missing on the morning of March 6th after you woke up.
Yes, I did notice my phone was missing.
And you claimed that you skipped school with Taylor to search for your phone.
Yes, Taylor and I were with each other the whole day.
Ms. Becker, you liked using your phone.
I did. I mean, in this day and age, every teenager needs a phone.
You, in fact, initially joined mock trial to use your phone with Taylor Perkins.
Yeah, Taylor and I joined mock trial together.
And you didn't notice that your phone was missing for over 12 hours.
Give or take, yeah. I mean, I had such a crazy week, and I just was so distracted.
Ms. Becker, you never made an effort to digitally locate your phone using iCloud.
I guess we did try to call and text it a lot, and we basically retraced our steps to go find it. We went back to the Fry Shack, and we went back to the mall. We tried to talk with the afternoon shift to see if maybe they had picked up my phone, but we never found it.
Yes, Ms. Becker. The only way you tried to look for your phone was to look all over at the mall and have Taylor Perkins call your phone.
Well, yes, as one does when they lose a phone.
And the only person who claims to have seen you at the time is Taylor Perkins.
Yes, but I promise we were with each other the whole day.
So let's move back to the day after regionals with the incident with Mr. Brackman. So you wrote Worst Attorney Award on the hood of his Porsche.
Yeah, I did, and I never should have done that. I never should have stooped to his level.
Improper character evidence.
Your Honor, this is not being offered to show that the defendant acted in accordance with a particular character trait. Under Rule 404B, this testimony is admissible as it goes towards motive. It also goes towards establishing the relationship between the defendant and the victim in this case, which I believe is a relevant relationship to have established for the jury's decision.
Reply, Ms. Seaman?
Yes, Your Honor, under Rule 404A2 or A1, this character trait, Ms. Becker's character trait of vandalization, opposing counsel is going to show that since she vandalized Mr. Brackman's car on one occasion, on a separate occasion, she would have gone to his house to vandalize this. This by definition is improper character evidence.
Okay, if that happens, I will take it up, but I don't think that's happening now. I will overrule the objection. Go ahead.
Thank you, Your Honor. Excuse me. You thought this would show Brackman what you really thought.
I just wasn't thinking. I was so humiliated and
upset. That is what you thought, though, Miss Becker.
Yes, but I also thought that it was a dry erase marker and that it would just come right off, like when you wipe a whiteboard down. I never knew that it was a permanent marker until
Miss
after
Becker, that is what you thought.
Objection, Your Honor. Interrupting the witness again. Ms. Becker has not been allowed to finish.
All right, Ms. Faulkner, please allow the witness to answer the question before you begin your next question.
Excuse me, I apologize.
Go ahead.
You knew he loved his car.
He would brag about how fast it could go at practice sometimes. His license plate read litigator.
And yet you never checked to see if the marker you were using was permanent.
I was about to go and write on the whiteboard all the good things that I did at the regional tournament, and then Coach Brackman began his whole spiel on how I should have stuck to his script, and then he humiliated me. And so I assumed that was what I had in my hand, because I mean, I didn't think that I was going to write on the whiteboard with the permanent marker.
Brackman yelled at you when he noticed his car.
He did. He looked pretty furious.
He said he'd had enough of your crap.
Yeah, he continued to insult me and Taylor too.
And he said that you screw around in practice and are disruptive.
He did, yes. I can't believe what I did to his car. Honestly.
Ms. Becker, he kicked you off the team.
Yeah, he did.
He told you that you could join that loser Taylor Perkins and play video games all the time.
Yeah, and I can't believe why you brought Taylor into this. I mean, it was totally my fault what happened to the car.
So that made you even madder.
Well, I was upset and I went home and I talked to my mom. And then I calmed down.
And when you talked to your mother, you told her that he had kicked you off the team for no good reason.
Yeah, I was naturally, I was kind of embarrassed, about everything that had happened. And I did tell my mother some things, yes.
And Miss Becker, you told her that you would get back at him if it was the last thing you did.
You're taking that completely out of context because I was just venting to my mother. I never would have carried any of that out. I never meant harm on Mr. Breckman at all. I never would have killed him. And I know this question insinuates that I did, and I can promise you that I did not kill Coach Breckman.
Miss Becker, in the heat of the moment, you told her that you would get back at him if it was the last thing you did.
Yes, I did, but I never meant to carry that out, and I never would have done anything else to Mr. Breckman at all.
Thank you, Your Honor. I have no further questions at this time.
Redirect?
Yes, Your Honor. Miss Becker, would you ever get back to Mr. Breckman?
Oh, gosh, no. Of course I wouldn't. He was my coach, and we needed each other. I never would have done anything else to him. I promise. I did nothing else besides write on his car. I never should have done that. I can't believe I'm here.
No further questions, Your Honor.
Cross?
Not at this time, Your Honor.
Then let's take a minute, and then I'll have is there another witness for the defense?
Yes, Your Honor.
Okay, I'll take that witness in a minute. All right, next witness for the defense.
The defense calls Taylor Perkins. Ms. Perkins.
Right, you may begin.
Thank you. Ms. Perkins, please state your name and spell your last name for the record.
Hi, my name is Taylor Perkins, Perkins.
Do you know the defendant today?
Yes, I do. Avery Becker is my best friend from high school.
What high school did you go to?
I went to CHS, Colorado High School.
Well, at CHS, did you do any activities or extracurriculars?
Yes, I did. Well, among other things, I did mock trial with Avery.
Why did you decide to join mock trial?
It was mostly to hang out with Avery and stuff. I'm not super passionate about being a lawyer or anything. I just wanted to hang out with my friends.
How long were you on the mock trial team for?
I was on it for about 4 years. I did step down in my senior year, shortly before regionals.
Ms. Perkins, you just stated that you were on the mock trial team for nearly 4 years with Ms. Perkins and Ms. Becker. I want to ask you some questions about Ms. Becker and Coach Brackman's relationship at that time. From what you perceived, what was their relationship like?
Well, based on my observations, Coach Brackman was always giving Avery a hard time about something. I mean, sure, Avery could be a little slacky on the work ethic sometimes, but she was a really good lawyer.
Were there any specific incidents where you recall them having an issue?
Yes, there was this one time Coach demoted Avery down to the B team for basically no reason.
What happened next?
Well, after that happened, I stepped off the entire team. I wanted to support Avery. I believe Alex called it a cheap move earlier. I don't really think it was. I really just wanted.
Sorry, is there an objection?
Yes, Your Honor.
Okay.
This is improper character evidence. The witness is testifying towards what Alex Fuentes has earlier stated in trial, and it is not aiding the jury's understanding of the situation at hand.
Yes, Your Honor, under Rule 404, evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with that character trait. Here, Ms. Perkins is not describing any character trait in which Alex Fuentes has and is acting in a particular accordance with, so it is not improper character evidence.
Any reply?
I'm sorry, I didn't hear that.
Any reply?
Yes, Your Honor. While under Rule 404A, I do believe that this is implying that Alex Fuentes has a vendetta against the defendant, and that character trait is trying to be used to prove that in a particular occasion that they're acting in accordance with this particular vendetta.
I'm going to overrule the objection. I don't believe it's improper character evidence. Go ahead.
Ms. Perkins, why specifically did you decide to step down from the mock trial team?
I just wanted to support Avery. Plus, I didn't really care about mock trial that much, so it wasn't a hard decision for me to make. I knew the A team couldn't survive without her.
What happened next?
Well, after I stepped down, Avery and the team won regionals.
I want to ask you some questions about March 5th, 2020. Where were you this day?
I was with Avery.
What did you, Miss Becker, do that day?
Avery had come over to my house. We just played some games for a while, and then we went to stop by the Fry Shack to grab a bite to eat.
Who was at the Fry Shack that day?
Well, while we were eating, the whole team showed up. I should have known. They go there after practice.
Do you recall seeing Miss Becker have her phone at the Fry Shack that day?
Yes, she definitely had her phone. The last time I remember seeing it was on the table.
What happened next?
Well, Avery got up and went to the bathroom. She left her phone on the table when she got up.
Who was at this table?
While Avery was gone, it was me and Alex Fuentes. He had come over at some point.
What happened next?
Well, Avery came back and then we headed out to the mall. We just shopped around for a while and then I went home.
Do you remember seeing Miss Becker have her phone at the mall that day?
No, I don't. I remember the last time I saw it was on the table at the Fry Shack, but I didn't see it after that.
Miss Perkins, you said you saw Alex Fuentes at the Fry Shack. How do you know Mr. Fuentes?
Well, Alex was on the team with us. I guess we talked sometimes because we spent so much time together.
From what you observed, were Alex Fuentes and Avery Becker friends?
No, definitely not. I mean, maybe on the surface they were polite and stuff, but deep down, not so much. I always thought that Alex was jealous of the roles that Avery got.
Do you know of a person named Blair Rollins?
Yes, I do. He was a student at CHS.
From what was Mr. Rollins' reputation at CHS?
Well, I mean, it was known about the community that Blair didn't really like Coach Brackman that much.
And why was that?
Well, I mean, it was known that Coach Brackman represented Blair's dad in some sort of trial, and Coach Brackman lost the case. So I guess I wouldn't really like that guy either.
From what you observed, were Blair Rollins and Alex Fuentes friends?
Yeah, they were good friends.
I want to ask you some questions about March 6, 2020. Where were you?
I was with Avery the entire day.
What did you, Miss Becker, do this day?
We had realized that morning that Avery had lost her phone, so we went to go look for it.
How did you realize that Miss Becker's phone was missing?
Well, me and Avery sort of have this routine where she'll pick me up before school sometimes, especially when we have a free period. I had texted her that morning to see if she was going to come and pick me up, but she never responded. She did end up coming that day, but once I got in the car, that's when we realized that her phone was missing.
Please tell the jury of all the places you went to that day to search for Miss Becker's phone.
We went to the mall, sort of looked in all the stores we had been in the previous day, And we went to the Fry Shack twice, once sort of in the morning, and then another time to check on the afternoon shift staff to see if anyone had seen Avery's phone.
What sort of efforts, besides looking for it, did you do to help find Miss Becker's cell phone?
Well, I called and texted Avery's phone a bunch of times just to see if we could hear it ringing or something, but we never did end up finding it.
Were you at Coach Brackman's house that day?
No, we were never there. Like I said, we were just looking for the phone.
You even know where Coach Brackman lives?
No, I think it would be kind of creepy if I did.
No further questions.
All right. Cross-examination?
Yes, Your Honor. Before I begin, I'd like to request how much time is remaining for cross.
Let me check.
Yes, I have 10 minutes and 53 seconds remaining for cross-examination.
Thank you.
Now, Ms. Perkins, you consider yourself Avery's best friend?
Yes, of course. I mean, at least in high school.
You were on the same mock trial team?
Yes, for 4 years.
Yet the only reason you joined mock trial was because Avery did it?
Well, I mean, that was most of it. I mostly just wanted to hang out with my friends. I'm not super passionate about mock trial.
Objection relevance, move to strike.
Your Honor, this is going towards the relationship between Ms. Perkins and the defendant. I think it's very relevant that this witness quit the team on the behalf of their so-called best friend.
Response, Your Honor?
Yes.
If that is the case, I would like to add an improper character objection.
Do you have a response to the improper character evidence?
Your Honor, under in methods of proving a character, this is merely going towards the relationship between this witness and the defendant, in which this witness has stated that they were the defendant's best friend. I don't think that is an improper character trait. It is what the witness has said themselves.
Reply?
Yes, Your Honor. Opposing counsel is trying to prove that because Ms. Perkins stepped down from the B team, or the A team, excuse me, and only joined mock trial because of her best friend, that she would go as far to lie on the stand today and create an alibi that is not true. And that is improper character evidence under Rule 404.
Well, I will allow it, and I think it's that your objection goes to argument. So go ahead.
Thank you, Your Honor. Moving on to the dynamics of the team, in your opinion, Mr. Brackman didn't like Avery because she put in little effort?
Yeah, I mean, from what I saw, that was the case. Brackman was always giving Avery a hard time about something. I think it was mostly because he seemed to think that she didn't put a lot of work in, but Avery was still really good on her own.
And in your perception, that drove Mr. Brackman crazy?
Yeah, sometimes I felt like I could see steam coming out of his ears.
And you found their feud kind of funny?
Yeah, I found it pretty funny, but I could see that it annoyed Avery a little bit.
It annoyed Avery enough to play some pranks on the coach?
Definitely to play some pranks, but not to murder him.
Moving on, let's talk about the practice about a month before the regional tournament. Avery came to practice the most unprepared you'd ever seen?
Yeah, it was kind of a problem for Coach. He got really heated again, and that's when she got demoted.
And after Avery was demoted, you quit the team to support Avery?
Well, yeah, to support Avery, and also because I really didn't care that much about mock trial. I mean, it wasn't a hard decision. I knew that Avery deserved to be on the A team, and they did end up winning, without me, I might say. So I didn't really think it was that big of a deal.
Moving on, you were not at the practice where everything blew up?
No, I wasn't there, but Avery did tell me about it after.
And you only heard from it from Avery?
Yeah, we were best friends. She was the one who told me about the incident. It was pretty upsetting for her.
And according to Avery, Coach Brackman was giving her a hard time.
Yeah, I mean, from what I heard, he was being pretty mean, saying some really rude stuff.
And Avery got upset?
She definitely did, but what she did was a mistake. She told me.
Objection, improper character evidence.
Response?
Your Honor, I don't believe this question calls for improper characterization. Simply asking the witness whether or not they perceived in their opinion that their best friend was upset, and that's not going to prove that the defendant or this witness acted in accordance in a future matter.
All right, reply?
Yes, Your Honor. Opposing counsel is trying to show that because Ms. Perkins perhaps perceived Ms. Becker as angry, that she would go as far to murder her coach in rage, which is improper character evidence, as it is proving a particular character trait acted in accordance on a particular occasion.
Again, I will allow it, and I will overrule the objection, and will allow you to argue that. So go ahead.
Thank you, Your Honor. And after Avery got upset, on the way out, she wrote Worst Attorney Award on Mr. Brockman's car?
Yes, that was what I heard. It was definitely a big deal for Avery. She tried to apologize so many times after, but Coach would never listen to her. She definitely felt really bad about it, at least from what I saw.
And she wrote with permanent marker on the car?
Yes, she did. But I don't think that at the time she knew it was a permanent marker. Otherwise, she never would have done it.
And after this, Mr. Brockman kicked her off the team?
Yes, he did. It was really upsetting for her.
Moving on, the evening of March 5th, you and Avery went to the Fry Shack?
Yes, we did. We were just grabbing a bite to eat. We sort of just hung out there a lot, so we had gone there to get dinner.
And then you went and hung around the mall?
Yes.
And it wasn't until the morning of March 6th that Avery realized her phone was missing?
Well, it wasn't until I brought it up in the car. Then we went to go look for it, yes. I guess she just didn't realize before that. And of course, I don't really know where she lost it. We thought it might have been at the mall or at the Fry Shack, but who's to say? We never found the phone.
Avery didn't realize her phone was missing for over 12 hours?
Well, I can't really tell you what Avery realized, but yes, that's true. She didn't realize it till we were together.
Despite the fact that, in your words, Avery's phone was like a third kidney.
Yeah, she was pretty attached to it. That's why we spent a whole day looking.
Nevertheless, when you realized the phone was missing, you ditched school on March 6th.
Yes, we did.
And you searched all over the mall where you had been the day before.
Yeah, we looked at the mall and the Fry Shack. Like I said, it took up basically the whole day. I mean, I really wanted to help Avery find her phone. Lord knows no one can survive without one these days.
And you burned the whole day searching?
Yes.
Yet in minutes, you could have found Avery's phone if you'd used the iCloud website?
Well, yeah, I totally forgot about the website. I mean, we might have still not found it. I'm not sure. But you see, Avery had an iPhone and I have an Android, so we couldn't use Find My iPhone. Sorry. But I totally forgot about the iCloud. It's not like we weren't looking for it or anything. I just totally forgot. It's spaced.
So you burnt an entire day searching and calling Avery's phone, but you never thought to use the iCloud website?
No, I forgot about it. Like I said, we were looking really hard, though.
Thank you, Your Honor. No further questions.
Redirect?
Yes, very briefly, Your Honor. Ms. Perkins, how serious do you take today's trial?
Oh, I take it very seriously. I mean, in my beliefs, every murder is one too many. I would never lie about this, and I know that Avery didn't do it. I was with her the entire day, and I would never tell you anything otherwise.
No further questions.
Recross?
Not at this time, Your Honor.
All right. You are excused. And is there another witness for the defense?
Yes, Your Honor. The defense calls Professor Blake Van Owen.
All right. You may proceed.
Good afternoon, Professor. Please introduce yourself to the court.
My name is Professor Blake Van Owen, Vanowen.
Professor, were you asked by the defense to give some expert opinions in today's case?
Yes, I was.
And did you reach any opinions?
Yes, 3.
Before we talk about those opinions, let's first discuss your background. Where did you go to school?
I attended CU Boulder, SCO Buffs, where I received my bachelor's degree. And then I went on to receive a master's degree from the University of Ashford, where I received a master's in criminal justice.
Do you have any specific experience in police work?
Yes, I do. I was a part of the police force for about 9 months. And then I went on to become a professor in the field of general police practices. In addition, I work as a private investigator. And as a private investigator, I work with the police force for the majority of my job.
And Professor, as a private investigator, have you ever testified in court like you're doing today?
Yes, I've testified in court about 25 different times, and I've been a consultant for over 100 different cases.
And when you were testifying in court, were you tendered as an expert?
Yes, I was.
And how do the practices that you've testified about in the past relate to the case today?
Of course, in the past, I've testified as an expert in the field of general police practices, crime scene reconstruction, as well as cell data analysis and recovery. Now, I like to think of it kind of like a candy maker. A candy maker is responsible to know all about candy corn, candy canes, and licorice. It's part of their job to know everything there is to know about those 3 types of candy. With that respect, as a private investigator, I'm responsible to know about these 3 individual fields to properly conduct my job.
Your Honor, the defense moves to tender Professor Blake Van Owen as an expert in the areas of police practices and investigation, including crime scene reconstruction and cell tower analysis.
All right, any objection?
Yes, Your Honor. Permission to voir dire. Thank you, Your Honor. Professor Van Owen, since leaving the police department, you have not worked as a police officer. Is that correct?
No, I have not.
Is it fair to say that you have not been exposed to police training nor protocol since then?
Not necessarily. If you're referring directly to training, that would be technically speaking true. However, I did go on to receive a master's in criminal justice, and I still work a lot of my time with the police force.
So that's a no.
Not necessarily. It's more of a gray area to that regard.
Is it true that you have not received any specializations outside of your master's degree in criminal justice?
Again, I was a police officer, which implies that I did go to cadet training where I did become a police officer ultimately. In addition to that, I do have training that I did not mention in my witness statement, if you would like me to testify further about that.
That's not necessary, thank you, though. You do not have any formal education in crime scene reconstruction, is that correct?
No, I like to say experience is the best teacher, and I've been working in the field for quite a long time, numerous cases, as you've just heard. So experience has really been my teacher in that regard.
So you haven't sat in a classroom and learned about crime scene reconstruction?
No, I have not.
Do you have any formal education surrounding cell tower and data analysis?
Again, all of my experience, 100 different cases consulted, 25 different occasions in which I was tendered as an expert. Experience has been my teacher in all of these cases.
Cell towers and crime scene reconstruction are not part of the curriculum you regularly teach, is that correct?
No, they are not. I teach social justice as well as general police practices and procedures.
Your Honor, I do object to Professor Van Owen being admitted as an expert witness in crime scene reconstruction and cell tower data analysis, as he lacks the sustained experience in and as well as formalized and specialized education in these fields.
Response?
Yes, Your Honor. Pursuant to Rule 702, an expert witness to be tendered in a specific area must have proper knowledge, skill, experience, training, or education. Given the disjunctive nature of Rule 702, he must only show one of these 5 requirements to be tendered as an expert. As he has just testified, he has sufficient knowledge, skill, and experience in the fields of crime scene reconstruction and cell tower analysis to testify as an expert today.
All right. I will allow him to testify. The objections to this witness being permitted to offer opinions as an expert go to wait. So go ahead, proceed. You may proceed.
Professor, earlier you mentioned that you reached some expert opinions. What were they?
course. To start, we have no real knowledge as to what happened inside of the home of Mackenzie Brackman on the day of March 6th during the time of the crime. In addition, we have no true evidence, concrete evidence, that can place Miss Avery Becker at the scene of the crime on March 6th. And finally, the prosecution's investigation of the death of Mackenzie Brackman was sloppy, rushed, and ill-performed.
Let's talk about Ms. Becker's location on March 6, 2020. Now, did you hear Detective Markowitz's and Kyle Kuzak's testimony today?
Yes, I did.
And do you agree with how they put, or of where they put Ms. Becker on March 6, 2020?
No, I don't. Now, there's a couple things to note about what Detective Markowitz said in this regard. To start, I'd like to know we have no evidence that tells us that Avery Becker had her phone. No investigation was done to investigate this topic as well by the prosecution. Second, they gave you a very deceiving analysis of what of what cell tower recovery and analysis tells us about a location. Now, they painted this picture that it performs like a GPS. That's far from the truth. What cell towers tell us is a phone's general area. And in this case, it would be a 120-degree arc radius with about 37.7 square mile area inside. That Miss Becker's phone was inside.
So can we know anything about where Miss Becker was on March 6, 2020?
No, we can barely place her phone in a general location. And that's making the assumption that she even had her phone, which you just heard she did not.
Now, Professor, I'd like to move on to the details within Mr. Brackman's house on March 6, 2020. Do you agree with the prosecution's investigation about the actual crime scene?
No, I don't. Specifically in regards to what occurred inside the home.
And what did you find?
Now, if we look at Mr. Kuzak's investigation, there were many assumptions. The struggle, the bear hug, all of these are not corroborated by the evidence. If we look at the struggle, the only evidence of this would be the scuff marks. We have no knowledge as to how these scuff marks were created, no knowledge as to when they were created. They could have been made by furniture being moved in through the back door, or they could have been made from stilettos, from heels. We have no knowledge as to how they were made.
And do you have an opinion about how Mr. Brackman died compared to the prosecution?
Yes. With the evidence, it's far more likely that Mackenzie Brackman was surprised and stabbed in the back by the intruder. This is supported by the coroner's report, as well as Exhibit 12, which is a video of the perpetrator entering the home.
What did you find in that video?
Now, upon entrance, the intruder opens the door and walks in without meeting any resistance. Now, that directly goes against what Mr. Kuzak said, that the perpetrator was met with resistance, and thus the scuff marks, which, mind you, are right inside the door, would have been created. Now, we can obviously see no such scuffle occurred.
Now, you also mentioned a coroner's report. How does that justify your opinion?
Now, looking specifically at the coroner's report, we can look at the knife and how it was put into Mackenzie Brackman's back. Now, when Mr. Brackman was stabbed, the blade entered at a very straight angle. Now, if it were to enter in such an angle, it would be almost impossible for it to be a bear hug fashion that he was stabbed in. Seeing as when in a bear hug, your arms and hands are curved in. Now, if this were the case, the blade would have entered at more of a diagonal slant rather than a straight entry.
What did this ultimately lead you to come to?
Ultimately, we have no knowledge as to what truly occurred inside of the home of Mackenzie Brackman on March 6th. It seems as though it's, with the knife in addition, the knife being brought to the scene of the crime, it seems far more likely that this was a premeditated attack on Mackenzie Brackman.
Now, you also mentioned that the prosecution conducted a faulty investigation. What did you mean when you said that?
There's a couple grounds for this. To start, they lost evidence. Next, the images they relied on, not authentic. And finally, they zeroed in on a single suspect the entire time.
Let's first talk about that lost evidence. What do you mean?
Now, the prosecution lost a piece of evidence. Whether it was important, I couldn't tell you. This evidence was images of blood spatter of the victim. I wasn't able to review these images, but the loss of evidence is what is really important, not what they could have done for the case. Losing evidence goes directly towards the work done by the investigators. When an investigator loses evidence, it shows they're not caring. They're putting little effort into preserving and going about conducting this investigation.
Objection, Your Honor.
What is your objection?
On the grounds of speculation.
Response?
Your Honor, I do not believe that Professor Van Owen is speculating about the loss of evidence. He specifically said that he wouldn't know what the evidence would have shown. All he knows is that a loss of evidence highlights a poor investigation done by the prosecution.
Reply?
Yes, Your Honor. I was specifically objecting to the testimony as to the careless nature of the prosecution, as the witness mentioned, and this also goes under improper character evidence, as this witness would not know how the prosecution was acting when they were conducting their investigation.
Your Honor, if I may.
I will strike that the portion of the testimony having to do with the careless nature, but allow the rest of it. Go ahead.
Detective, you also mentioned losing screenshots. What screenshots did you mean?
Apologize, it is Professor. And in regards to the screenshots, those were the text messages you heard and saw earlier. Those text messages were supplied as through screenshots. Screenshots in their nature are unreliable and can be forged. The detective, Markowitz, was very capable of sending a car to go retrieve the phone, or could have used their knowledge in regards to Celebrate to recover this data directly. However, they chose not to.
Finally, Professor, did Detective Markowitz investigate, in your opinion, or in your investigation, did he investigate any other suspects?
No, it's ridiculous. When you're investigating the murder of a defense attorney, someone who defends those who have committed crimes, it would be logical to think it was possibly a wronged victim. Now, going into this investigation, Detective Markowitz knew this. However, he decided to investigate a high school student. It's as if you're in the middle of a field in Kansas and you hear hoofbeats. Detective Markowitz, instead of thinking horses, thought zebras. It makes no logical sense.
Did you yourself investigate any other suspects?
Yes, I did.
And did you find any credible suspects?
Yes, the key one being Blair Rollins.
Was Blair Rollins associated with any Colorado high school students or administrators?
Yes, Blair Rollins was associated with Mr. Brackman. Mr. Brackman defended Blair Rollins' father, Jonathan, in a murder trial in which Jonathan Rollins lost and was sentenced to jail.
And what was the outcome of this murder trial?
Ultimately, Jonathan Rollins lost the case. And as he was being pulled away, he made a threat. He said, "I'll get you back, Brackman, if it's the last thing I do."
Now, do you have any knowledge if Blair Rollins was in the room during this trial?
Blair Rollins testified on behalf of his father. Therefore, he was present for the trial and likely heard this statement being made.
Now, after the statement was made and on March 6th, 2020, do you know where Blair Rollins was on that day?
I can tell you this, Blair Rollins was not present at school. We have no knowledge as to where Blair Rollins is now. I wiped off the face of the earth after graduation.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination?
Yes, Your Honor. Professor Van Owen, to date, you have made approximately $7,000 for this case. Is that correct?
Yes.
And as a private investigator, you were hired by the defendant in this case. Is that correct?
Yes, that is.
Is it true that you think of yourself as a check on the power of the police?
Yes, it's the police's responsibility to bring justice in our country. And I'm here to make sure that is enforced and that actually happens. In this case, it's not.
Furthermore, you think the police, quote, cannot see beyond their own noses?
I think I refer to specific officers in that situation. And that would be in regards to the officers involved in today's case.
Yet you use these officers' police reports as the basis of your investigation. Is that true?
I apologize. I don't understand directly what you mean. If you're asking that I use what the prosecution provides me when I conduct my investigation, that would be true. That is the nature of private investigation, as I'm hired well after the crime scene has been completed and cleaned up.
Moving on, I'd like to ask you a few questions about your investigative work. You never visited the crime scene for this case?
Again, by the time I was involved, the crime scene had been already cleaned up. So I was limited to the images provided by the prosecution.
You simply reviewed Mr. Kuzak's reconstruction report.
Yes, exactly. As well as the images, the coroner's report, everything that the prosecution provided me, I did review, including Mr. Kuzak's report, yes.
And you simply reviewed Detective Markowitz's report?
Yes, I reviewed it, and then I also actually did conduct a partial investigation of my own. As I did note earlier, I investigated Blair Rollins, as well as alternate theories as to what could have happened inside of the home of Mackenzie Brackman.
You also admit that holding a knife, the way you suggest the assailant did in your report, is uncommon. Is that correct?
Yes, uncommon, but not impossible. It's quite possible. I mean, when someone is stabbing someone, I personally don't know, but I don't think they're focused on the way they're holding a knife.
You also did not obtain the cell tower records the day prior to the murder to corroborate the defendant's alibi. Is this also correct?
I think you're misunderstanding my job. It's the prosecution's job to provide the burden of proof. I am simply here to analyze their investigation. The prosecution should have done this job, not me. Although you are correct, it would have been better if I did. However, again, it's up to the prosecution to do this.
Thank you, Your Honor. Thank you, Professor Van Owen. I have no further questions.
Redirect? I think you have less than a minute left.
No redirect at this time, Your Honor. May my witness be excused?
Yes.
And
The
Your
objection
Honor,
to the witness being excused?
No, Your Honor.
All right, the witness will be excused.
Your Honor, at this time, the defense rests.
Thank you. Now we will proceed to closing arguments.
Your Honor,
So,
oh, excuse me, I apologize.
so let's begin with the prosecution. And do you want to reserve any time for rebuttal?
Yes, Your Honor, that's what I was actually about to request.
Okay.
So thank you very much.
Okay.
I appreciate it.
All right. And how much time do you want to reserve for rebuttal?
I would like to reserve all remaining time once I finish my first statement. Thank you.
Go ahead.
I'll get back at him if it's the last thing I do, were the words of the defendant in this case mere days before brutally murdering Mr. Mackenzie Brackman in his home. Members of the jury, you are here today to answer a simple question. Who killed Mr. Mackenzie Brackman on March 6th, 2020? In this case, the defendant had a motive and an intent to hurt Mackenzie Brackman, along with a demonstrated history of impulsivity and vengeful, rash behaviors. During their time in mock trial, there were constant arguments between the defendant and the victim at mock trial practices. The defendant was underprepared for practices, relying on their good looks and improvisational skills to help them complete tasks on the team, leaving the victim in a state of constant anxiety. Ultimately, the victim kicked the defendant off the mock trial team for their constant bad behavior and arrogance. As the defendant themselves testifies, they had an enormous argument with the victim after the regional competition, in which they called him the worst coach in the state. Immediately after this incident, the defendant wrote Worst Attorney Award across the hood of the victim's Porsche in permanent marker, leading to yet another massive argument. After the incident, the defendant told their mother they would get back at him if it was the last thing they did, texting Alex Cifuentes with their plan to trash the victim's house shortly after. The defendant denies having sent these messages, despite the fact that Cifuentes provided screenshots to the investigators in this case, and has testified under oath to having received these messages personally from the defendant. The defendant clearly had a motive and an intent to commit the charge of second-degree burglary of the victim's dwelling prior to March 6th. The evidence of this intent continued on the day of the crime. The defense claims that the defendant missed school to search for their lost cell phone. However, both Becker and Perkins have also testified that the defendant was extremely attached to their cell phone. Perkins even refers to the phone as Becker's third kidney. It's basically impossible that the defendant would have lost their phone on the early evening of March 5th and completely failed to notice until they woke up the next day on the morning of March 6th. This is one of the many discrepancies in the defense's theory of the case. Additionally, Detective Jordan Markowitz with the Denver Police Department has testified that the defendant's call detail records are consistent with a route connecting to fully 3 towers in a row that would lead them directly from their dwelling to the victim's dwelling. Members of the jury, that means that according to their own cell phone, shortly before Mr. Brackman's death, Avery Becker was driving to his house. Attendance records at CHS also show that Avery Becker was absent from school on March 6th, and the only person to have seen the defendant at the time the victim was killed was their friend, Taylor Perkins. As you've heard today, Kyle Cusack, a crime scene reconstruction expert, has shown that Mackenzie Brackman's death is consistent with a murder committed in the furtherance of the crime of second-degree burglary of a dwelling, qualifying it as a voluntary instance of felony murder. In this case, the prosecution must prove beyond a reasonable doubt that the defendant, Avery Becker, committed second-degree burglary and felony murder. The testimony you've heard today provides ample evidence to prove that the defendant had a motive, a history of rash behaviors, and a demonstrated intent to commit the crime. The defense has tried to raise the specter of an alternate suspect named Blair Rollins in this case, but their entire theory is based on speculation, since their hired gun, Blake Van Owen, chose not to pursue any real evidence related to this suspect, and instead chose to focus on baselessly discrediting an oversimplified version of Mr. Cusack's work. Their theory comes down to speculative claims of cloaks and daggers, while there is concrete evidence for convicting Avery Becker. We are left with the simple question of who killed Mr. Mackenzie Brackman, and it is unclear who could have killed Mr. Brackman, besides Avery Becker, his longtime rival who promised to get back at him if it was the last thing they did. Members of the jury, the evidence is proof enough to convict the defendant of the charges against them. Vote in favor of convicting Avery Becker. Thank you.
All right. Thank you. Does the defense want to do a closing argument?
Yes, Your Honor.
Okay, please proceed.
Members of the jury, I'd like to simplify the prosecution's arguments that you just heard. You just heard a story about a high school girl who was apparently so upset about an extracurricular activity that she killed her coach, whom she knew well. That is all the prosecution has. And as a result of a rushed investigation, they're willing to put a high schooler in jail, potentially for the rest of her life. This is a mockery of justice. Now, you heard that Mr. Brackman and Ms. Becker didn't have a great relationship, that after she won 2 awards, she was demoted from the A team. In a moment of weakness, she rode on his car and was kicked off the team. Is that enough evidence to convict someone of murder without a solitary eyewitness and mere circumstantial evidence? The Denver Police Department thinks it is. The prosecution arrived at some speculative conclusions about the events of March 6th, and I'd like to talk about them. They want you to believe that Ms. Becker was so upset that she drove to her coach's house to vandalize it. Then they want you to believe that Mr. Brackman didn't call the police and instead armed himself with a knife, and that Ms. Becker either didn't see him inside the glass door or didn't care and attacked him anyways. Then they want you to believe that once this high school girl attacked her middle-aged man coach, she gained control of the knife and stabbed in the back. Then Mr. Cusack wants you to believe that Mr. Brackman pulled the knife out of his own back after the intruder fled the scene. Ladies and gentlemen, that morass of speculation is what you heard. And it's also what Professor Van Owen was presented with. As you heard, Professor Van Owen uncovered the inconsistencies in the prosecution's case. He described how cell tower data is not helpful for pinpointing a location. And even if it did put Ms. Becker's phone at the scene of the crime, it still doesn't put her there. Detective Markowitz didn't deem it necessary to ask for Mr. Cifuentes' phone. Instead, she was fine with screenshots. screenshots that could have been faked or created by Mr. Cifuentes. And if you thought that not collecting all the evidence was bad enough, you saw that Detective Markowitz moved the victim, Mr. Brackman, between taking pictures of evidence. Furthermore, Detective Markowitz and Kyle Kuzak both lost the same images that would have given us a clearer picture of where Mr. Brackman was murdered. Was he killed at the back door? Or was he killed sitting down? We just don't know. But what we do know is that every piece of evidence presented to you by the prosecution was done so in a selective manner. The state knows there's another suspect, Blair Rollins, whose father threatened to kill Mr. Brackman while he was in the room. But they chose not to investigate, and they chose not to tell you. Instead, they pushed their own narrative and made a mockery of justice. Now, I'd like to remind you that Detective Markowitz doesn't determine who is guilty. Neither does Kyle Kuzak, and neither does Professor Van Owen. You, members of the jury, are the sole arbiter of this case. You determine who is guilty and who is innocent. The prosecution just mentioned the jury instructions, specifically jury instruction number 8. Read it carefully, because you must be convinced that Ms. Becker knowingly broke into Mr. Brackman's house with the intent to commit criminal mischief. Then it states that the prosecution holds the burden of proof, that they must prove beyond a reasonable doubt that Ms. Becker was the intruder. The quote, "I'll get you back, Brackman, if it's the last thing I do," was not made by the defendant. It was made by Jonathan Rollins while his son was in the room. We don't know who went to Mr. Brackman's house on March 6th. We don't know who murdered him. But what we do know is it was not this high schooler. There is doubt everywhere you look. Stop this mockery of justice. Thank you, Your Honor.
Any rebuttal?
Yes, Your Honor. Members of the jury, the defense has invented doubt. The defense has accused the people of speculation, but has failed to demonstrate the invalidity of any of our evidence with evidence of their own. Follow the evidence. Follow the defendant's own words of intent. Vote to convict Avery Becker. Thank you.
Thank you. So now we're going to give a few minutes to our panel, our scoring panel, and then we'll take some time, a few minutes to give some critiques. So let's take about a 2-minute or 3-minute break right now, and we'll come back and we'll proceed that way. Thank you.
So we're just waiting on the one score sheet, and then we can start the feedback. If the judge and the other scorekeepers want to start doing feedback while we're waiting on the final score sheet, that is okay as well.
Well, I would rather wait till we had all the scoring panelists sheets in, and then we'll give feedback. Because I don't want to influence the scoring panelists.
Okay, thank you.
Just have to say, everybody looks so happy. Round two's done, right?
Well, why don't we proceed? I don't want to get caught up with time. Ms. Luttrell, you first.
Yes, Your Honor. Thank you. Well, first of all, I want to say I'm very impressed by all of you. I think you did an incredible job. Clearly, you've been working on this for some time and have put a lot of time into preparing. So I hope you're all giving yourselves a pat on the back for that. I think that overall, I feel like everyone did a pretty good job of making eye contact with the camera, of not reading, which is one of the things that I think that makes for a really, strong presentation. And trial attorney is if you're not just reading. And so I wanted to say that I thought, overall, very good job at that, and very good job at giving inflection into your voice, so it wasn't just as if you were reading something. I would say, on the same token, be careful of the tone of voice, because it's a fine line between having the inflection and maybe sounding just slightly dramatic. And it's a fine line. It happens in trial too. I know I've done it. I've been a trial attorney for 15 years. But just kind of be careful. Am I being persuasive, or do I sound like, maybe it's a little bit dramatic? So that's one thing that I would just caution overall. As far as witnesses too, I thought folks did a really great job. The witnesses were phenomenal. Like, you guys just put so much work into this. It was incredible. I particularly liked how the witness for the defendant had some emotion, didn't seem just completely flat, which is kind of a problem sometimes when you do mock trials with witnesses. A defendant's going to have their life on the stake. So you want to have somebody who shows that they're impacted by it. By the same token, though, be careful that it's not just a little bit, maybe too much sometimes. So I would caution that slightly. And if it happens, I would say prosecution use it, because it seemed to me in some ways that the witness was saying, oh, I couldn't help myself with the marker. I'm so sorry. I don't know why I did it. Well, okay. Yeah, you can't use that as propensity, but she has just kind of shown herself as being a hothead who's not really in control of her emotions. So maybe paint her as an emotional person who can't really control herself. You have to be careful, when there's a 404 view, because it's a limited purpose type of thing. But the jury's just seen this person acting very emotional in the stand, and you can infer from the emotions and from the demeanor in the stand. But I don't want to take up all the time. So those are the immediate things that kind of stuck out for me. And again, especially with the objections, you guys spent a lot of time preparing those. Good job. And especially, I would play up speculation a lot more, because I think there was a fair amount of witness speculation. Oh, my last point, sorry. Self-serving hearsay. Self-serving hearsay does not come in unless the prosecution opens the door to it. As a prosecutor, I have to be very, very careful about that. So yes, the statements of the defendant come in, but not the ones that I don't introduce that just help them. So there were some places where the defendants said things, or people said the defendant said things that were really just to help the defendant, and that weren't necessarily brought in through the prosecution's case. I would object. Self-serving hearsay, that does not come in, and they probably won't have a good response to it. So just a thought on that, but thank you.
No big deal at all. Okay, take care.
Mr. Myers.
All right.
All right. So I just had a couple of things. I want to echo some of the comments that have already been made. I think you guys have done a phenomenal job, especially given the format. Kudos to you all for hanging in there throughout all this stuff. Couple points, broad picture. I think it's important that you can be firm, but not angry. And so I think it's really hard when you get so passionate about what you're doing that you kind of forget that you kind of come off extremely abrasive, which can really color your whole discussion that you're having with a witness and or the attorneys. So I'd put that cautionary tale out there that it's okay to be firm, but you don't need to be angry. On the same side, when you have a witness that's being very difficult, I think kudos to you, Octavia, for being a difficult witness to some degree. That's good points for you. And then Sadie, this is where I had my note, was it's okay when you're trying to control a witness to just end your question with correct. Isn't that right? Or if you have to. Not all the time. Sometimes it gets over the top and it gets badgersome to some degree. But in that case, you can also say, is that a yes or a no? Because I think that will help you. Thomas, I wanted to give you kudos. Your statement, it's not my job, that's the prosecution's job, more or less. I think that was really, really well done. I liked that. And then I guess, I know it's really difficult. You've already prepared thus far and you're already into round 2. I prosecuted for about 7 years or so. And the whole theme of cops are horrible people, prosecution's this miscarriage of horrible travesty of justice. I guess perhaps that just rubbed me personally wrong, because that's not what it is. They may have made mistakes, but they're not. I don't know that they're doing this all on purpose. And it kind of came off a little bit rough in that regard. But generally speaking, I think you guys did a great job. Last point for both teams to consider. Objections are extremely important, but you got to weigh that with being able to tell the story and getting the facts out. I think we spent a lot of time on the objection pieces, on character evidence, et cetera, et cetera. When it comes to real life practice, there's some objections you have to make in order to preserve things for the record. And there's a lot of objections that just try to do your best of weighing whether or not that's going to really be damaging to your case, because every time that happens, you're giving up time to do what it is you need to get done, especially in a mock trial setting where the time limits are very, very rigid. In a normal trial, you have a little bit more leeway, but just some things to consider is to make sure you're very conscious with your objections. But I think you guys did a really great job, and thanks for letting me participate.
All right, thank you, Mr. Myers. Mr. Carboni.
First of all, I again would like to say thank you for allowing me to participate. I enjoy watching the energy and the professionalism of the students. And I thought the whole process was well done. A couple of key points that I felt on Ella, I thought that the good development of shifting focus to the witness and benefiting from the situation, developed your cross-examination well, and it was good development. Same was true, I thought, with Michael on cross-examination. Then on Anna, a good challenge of the visual evidence, well-developed questions. On the side of the prosecution, I thought that in the opening statement, Camilla, that good flow. The discussion just flowed very nicely and very naturally. And there were good points made by Camilla on redirect on the examination. The fluent, very pervasive on the witnesses. On Isabella, I saw that the questions developed based on the logic of how you went from one item to the next was well done. And the conclusion reduced, this is now Dylan, the conclusion deduced from evidence that you found. It was nicely followed through. On the witness now here, Katrina, I found it credible hearing you talk, and it was nicely done. Same with on direct examination by Sadie, well-developed questions. So all in all, I've got comments on all of them, but I don't want to take up all the time. It was well done, and I appreciated the level of work and consideration that you went through to make this successful.
All right, thank you, Mr. Carboni. Do we have time left? And I could make a couple comments.
Yeah, we have time for you to make a few comments.
Okay. Well, I hate to sound like a broken record, but I echo what my colleague said. I mean, the level of preparation was very clear and was great. And thank you for the dedication, and thank you for letting me participate in this. And now I'm going to use Ms. Seaman and Ms. Faulkner as examples of how at some point you were talking really fast, and then you slowed yourself down. And I thought that was great because, you start off wanting to do something and seeing, oh gosh, I shouldn't have done it this way, and then you change it. And that's human nature. And that's a great quality to have. So really don't be upset with yourself that, oh, you're doing something, you just fix it. You're just doing something you don't want to. The witnesses all were very, and Ms. Gomez, I thought you were all very prepared, and you had great personalities. And then that's what makes a trial. Each witness is different, and you have to handle the witness in a different way. I mean, matching the personality of the witness. The redirect is an opportunity which you took to make points, and that's when everyone's listening. And I want to say something about the openings and the closings. The openings are really supposed to be factual. What is the evidence going to show? And I think that you did the openings in a way that met that. And the closings need to be argument. And you did that too. And that was really great. That it's very tempting to kind of cross that line, especially in openings, to cross the line into argument, and you didn't do that. So that's, I think that you all did a great job. So anyway, thank you. And I think we're through. Or if you have any feedback for us, for the students, well, you're all in this and you want to see your scores, and you want to, I know that you want to go to round 3. So, all right, that's all I have.
Thank you, Judge.
Thank you.
Thank you.
Thank you to all of the volunteers today and all of the students, and good luck in your next round.
Thank you.
Thank you.